ওটা একবার ড্রাফট দেখিও আমাকে কারেকশনের ড্রাফট নাহলে আবার ওটা কারেকশন করতে হবে yes
Interim order was up to 20th June, my lord. 25th of March 2025 order was passed, my lord.
So let's kindly extend the interim for a limited period because the entire proceeding has been stalled. It was auction of a sand block. There were some technical glitches alleged by the writ petitioner for which an interim order was passed.
Original interim order was passed on
Lordship, on 31st of January
2025.
that the tender shall not be finalized.
sir I want to know when the interim order
31st of January by Honorable Justice Amrita Sinha. January 31,
January.
2025.
30 matter was taken up, then it was adjourned for the next day. Next day, 31st January.
sir I shall hear you sir have patience will you read the relevant portion of that order
31st January 2025. The respondent or
31st January
31st January.
Legal order was
oh I'm sorry
January 31.
This order, well.
the respondents are restrained from finalizing the bid till very good
Thereafter, my
then
lord,
what happened
so thereafter on 30th February it was extended.
the respondents shall file their affidavit in opposition in the application why in the application
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 filed
for-
by me, my lord. I am the private respondent. Lord, I file a vacating application. Vacating of the interim order.
That was
My lord,
there is no direction for a exchange of affidavit in the
The
main
writ
matter
petition.
yes. On 25th of March order,
25th, yes, 25th, possibly it was AO by
25th of
Yes.
March.
25th of March of which year sir
2015 by Justice
2025.
Aniruddha Roy.
Last order, man.
25th March
Yes, madam.
2025
25.
the entire order has been passed upon Can 1 of 2025
Yes, madam. That vacating application was filed by my learned friend.
sir try to understand my
Yes.
question sir have some patience and listen me properly I have understood that Can 1 of 2025 is at the instance of the private respondent for vacating the interim order. Now listen to my question. Whether in the main writ petition there was direction for exchange of affidavit or not.
Yeah, it appears, my lord. On said order, it appears, my lord. The respondent shall
Lordship,
file.
kindly come to page 6 of that
Page
order.
6. Kindly.
Page 6 of order dated 25th March
Respondents shall file their affidavit of opposition
in
in
the
the application.
and also in the main writ petition.
Where is the affidavit of opposition?
Because the opposition I have prepared, it is because of the NIC that was the required party. We have sent it for their confirmation.
Where is your affidavit of
My
opposition?
lord, kindly before that, my lord, I could not prepare because my lord, kindly see the earlier paragraph. But the amendment direction was made to the petitioner to my lord amend and my lord add the party of NIC.
I have
And my lord, that application should be served to the appearing parties. Till date they have not my lord served.
Which was not served?
My lord, the amendment application.
amended. Leave was granted to amend NIC party. I was made him party.
My lord, kindly see the my lord, the order. Kindly see the order. Kindly see the order. My lord, after considering the submission as
Page
recorded.
number, page number.
My lord, page. my lord,
Difficulties there is no
my lord, page
paragraph
5,
number. That is the
Yes,
difficulty.
yes.
page 5.
Huh.
My lord, the bottom.
Hmm.
Well, after considering the submission as recorded above, it appeared to this that the National Information Center (NIC) is required to be implemented at the writ petition. Accordingly, the said authority is directed to be implemented at the writ petition, and the implement shall be caused in the cost title of the original petition by putting a signature of the learned advocate of record. Copy of the writ petition shall be served upon the appearing respondents. As also the already and also the newly implemented respondent affidavit of service. Yes,
A copy I saw to the NIC.
appearing respondents also.
Appearing. এড পার্টি তোমাকে কপি কি সার্ভ করবে?
তাহলে this is the order of this honorable court. Did you comply that?
Copy of the amended writ petition shall be served upon the appearing respondent.
Well,
So you make necessary endorsement in his copy.
yes, well, I will give you a copy. Well, I
The
have,
copy.
Yes, yes.
I will in course of the I will submit.
Because as per my submission, the NIC was implemented as a
Yes, party
party
I have
because it is a required
For
party.
the NIC.
NIC was served the copy.
But affidavit service, there was a direction
Yes,
to
yes,
file.
I-
I'm not
I-
sure
I-
whether it has been.
Affidavit of service.
What is the affidavit service?
Well, affidavit of service is not ready, but I have served the copies there, madam.
Then I will not extend the order.
Well, kindly,
Let
madam.
it expire.
Well, kindly, madam.
Why?
I will in course of the I will file the affidavit of service. In course of the madam. In course of the I will file the affidavit of service.
Ashun.
Lordship, I am for the state respondent. State is not the answering respondent here, madam.
Can 1 of 2000.
Four and five. Lordship, praying for not today.
I am for the Union of India.
देखिए 300 আপনি জন্য আছে আগে দেখি
And arbitrated by law have not the right to but
Let the matter be listed under the heading fixed motion on July 2, 2025 under the same heading.
July?
Same order. 3, 4, 5 সব একই অর্ডার করে একবার দেখিনি অর্ডার গুলো আমাকে দেখিনি একবার identical matters. Yes. Oh, then it's all right. 3, 4, 5 identical matters.
Fixed matters. Fixed motion. Date of arrival, 7.
number 6. I appear for the petitioner. Lordship kindly peruse the last order passed by your Lordship on 29th of April. The alleged contemner, they sought time to take steps to comply with the direction passed by your Lordship. On the last occasion, the contemner were represented by Mr. Orijit Dey. In spite
Where
of,
is Mr. Dey?
he was here. In spite of that, although he appeared, I also served the server copy of this order for the.
Oh, Mr. Dey is here.
Dey is here.
It has been complied with.
That steps are being taken. Lordship kindly gives me a week's time. A week's
Till
time.
date,
Yes, a week's time.
And
Week's time.
that-
I just now I was here in the morning, but I was just calling, having a talk with them. I called them on phone. Lordship kindly gives me a week's time. Lordship only adjourns this for a week's time. Lordship kindly,
আসুন ভাই
but kindly.
On behalf of it is
I'll comply with Lordship's order. My lord. No. But I was only praying that it will be complied. I was in the event Lordship has passed your Lordship's order.
not to appear in virtual mode, Without the order, the court knows how to implement it.
No. That
All
is
the next
my
matter.
only thing. Could we take it up day after tomorrow? Tomorrow I have some personal difficulty.
Very good. Today at,
Thursday only.
today at 4 p.m.
Very good. I'll come back.
Today at 4 p.m.
But-
Instead of tomorrow at 10:30, today at 4 p.m.
I'll come back tomorrow.
There must be a limit of everything, sir. Call the next matter.
Get to-
My lord, I'm for the petitioner, my lord. My lord, this is an contempt application. My lord's order and judgment dated 24th December 2024. My lord, challenging this judgment, respondent,
Let the file be placed first.
Fine.
For the first time it is appearing.
my lord, first time appear.
Yes, sir.
My lord,
Sanction plan was cancelled.
my lord,
Respondent imposed a cost of rupees such and such
yes,
payable by the Pradhan. Directed to refer to the matter to the SDO.
my,
The jurisdictional SDO is directed to conduct appropriate proceeding. Yes. What is your grievance?
my lord,
Have they
challenging,
preferred any appeal?
yes, my lord, they have prepared appeal. My lord, appeal has come up for hearing before my lord, the Honorable Justice Devanshu Bosak and Sabbar Rushidi.
What happened
After
there?
hearing, they have affirmed my lord's order.
My order has been affirmed.
My-
Very good. Ashun.
My
At
lord,
the time of
my lord,
hearing,
1 minute, my lord, Pradhan prepared an appeal, they withdraw the appeal. And thereafter they comply the cost. My lord, Pradhan referred the matter to the SDO. SDO took up the matter for hearing and pass an order, my lord, directing the private respondent to demolish the unauthorized construction within 9th April 2025.
9th April, yes.
In
Then-
default, the authority will itself effect the demolition and recover the cost thereof from them as public demand. My lord, kindly come to page 39 starts, my lord, last 40 page.
Then why you have filed the contempt application?
My lord, last part, my lord, if in default, the authority will itself effect the demolition.
Page number 39.
My lord, 39 starts, my lord, last page, my lord, page 40.
Hmm.
40 bottom, my lord, are hereby directed to demolish the erect made in plot numbers as mentioned above in contravention of the provision of section 1 of the said act on or before 9th April 2025. And in default, the authority will itself effect the demolition and recover the costs thereof from them as public declared. Last portion they have not done. Malab, private student not demolish. SDO sat tight over the matter.
No, then you come to paragraph 20 of my order. Kindly place, sir.
Yes, my lord.
Kindly place, sir. Paragraph 20 of my order.
The jurisdiction SDO is directed to conduct appropriate proceedings
Huh.
under section 23(5) and 6 of the West Bengal Panchayat Act
Huh.
1973 within 3 months from the date of receipts of the reference from the respondent number 7 Pradhan Jagadishpur Gram Panchayat, Howrah, after complying due formalities as ensured in section 23(5) and 26.
So that has been done.
No, my lord, 26 says that if the private respondent not demolished, then the SDO will demolish. 26(3), my lord.
No. Is directed to conduct appropriate proceeding within from the date of receipt of the reference after so they have conducted the proceeding. Why the contempt?
But they have not done the 26(3), 6.
So how the read will lie, sir? How will read the will lie?
My lord,
They have completed the proceeding. They have passed
Proceeding.
an order.
but they have not done the 26.
Then
36.
contempt will lie. Then contempt will lie.
My lord, 26.
Am I here to advise you?
26(3) clearly says if the
File a separate prison for implementation of that. Asun, asun, asun.
26(5) my lord says
At
if
the time of hearing,
respondent
learned
did not
advocate for
done,
the-
then the SDO will demolish the same.
no. That for which contempt will not lie. At the time of hearing, learned advocate for the
26(5) my lord.
learned advocate for the writ petitioner draws attention of this court to the copy of the judgment dated
My lord, according to last order on 9th day of June 2025, I have served the notice upon the landed advocate appearing on behalf of the my lord highest authority, and my lord directed to file a report with this court. This is my lord affidavit of service and also order in this affidavit of service.
You are the answering response.
My lord, here, my lord, his grievance lordship mainly is not receiving the compensation, my lord. So, my lord, the disbursement of compensation is the authority of the competent authority, my lord, the Kala.
Who is for the state? And who is for the respondent number 6, Union of India?
My lord, as per understanding of this petition, my lord, my learned friend lordship, on the basis of the assumption.
It is his petition.
My-
I am to hear him first.
My lord, here in this case, my lord,
Give me a second. Yes.
my lord, the father of the petitioner, my lord, purchased the property, and thereafter that property was gifted in favor of the petitioner. My lord, having plot number, my lord, here. Plot number 97, having my lord total measurement 62 decimals, my lord, which appear, my lord, page, my lord, 23, and my lord, scheduled property, my
Plot
lord,
number 97.
97, my lord, Mouja is my lord, Madan Mohanpur,
Huh.
measuring,
62 decimals.
yes, my lord, that was
By deed
gifted
of
by
gift.
by deed of gift.
Yes.
On 30, what is happened, my lord? My lord, when the deed of gift, my lord, is existing in favor of the my lord, petitioner, the state government by initiative and vesting proceeding, that vesting proceeding was set aside by this honorable court. Not this plot, but in respect of my lord, 3 brothers, petitioner and my lord, 2 brothers, set aside. Thereafter, my lord,
Which vesting was set aside?
the vesting was initiated in the name of my father,
In respect of plot number 97.
not that.
Plot number 97
No,
was the not
It
subject
is
matter of
free-
the
no,
vesting.
no, it is free from all incumbrances. This is my
What happened thereafter?
Thereafter, my lord, kindly state to my lord, turn to page 72. My lord, the notice was published, my lord, by the central government, my lord, Highways Authority,
Page number 72.
to Annex 38, my lord.
Yes.
And may I read it?
Yes, sir. Yes, sir.
National Highways Act 1956 and 1956 actually says, CA ধারা উপধারা 1 অতঃপর উক্ত আইনের অবহিত নূতন ক্ষমতা প্রয়োগ মূলে কেন্দ্র সরকার পশ্চিমবঙ্গ রাজ্যের পশ্চিম মেদিনীপুর জেলার খড়গপুর বর্তমান
Sir, adjust the microphone. Adjust the microphone or you go back to your
All
left.
right, my lord, I'm sorry. My lord, that notice was, my lord, served, my lord, under section, my lord, 3A and
কেন্দ্রীয়
1,
সরকার পশ্চিমবঙ্গ রাজ্যের মেদিনীপুর জেলায় খড়গপুর বর্ধমান মোরগ্রাম ইকোনমিক করিডোর সেকশনের 0 থেকে 56,000 কিলোমিটারের রক্ষণাবেক্ষণ
500 কিলোমিটারের রক্ষণাবেক্ষণ পরিচালনা এবং নির্মাণের প্রশান্তকরণ
তফসিলে দেওয়া জনস্বার্থে প্রয়োজন
প্রয়োজন।
জমি অধিগ্রহণ উপায়ে অভিপ্রায় ঘোষণা করিতেছেন। Very good.
করিতেছেন।
Then what happened?
Thereafter, my lord, what is happened? It is directed, my lord.
Now in the schedule, your land falls.
No. My land means my schedule comic number, my lord, serial number 52. At the
Plot
bottom.
number 62 is within the schedule of this
52,
notification.
Yes, 52 on the same page. At the bottom.
Item number 52.
Yes, my lord, serial, which comic number 62. My lord, plot number 97, you also got it.
Plot number?
97.
Oh,
On the
yes.
serial number 52.
Yes,
same
plot
page.
number 97.
97.
In the same Mauja.
Same Moja.
Madan Mohanpur, yes.
Madan Mohan.
Gram Madanpur, GL number 236.
But this is the, my lord, the plot, my lord, which is
So
required.
97 Angsi is a part.
Unsaid part, but this part, my lord, as I, my lord, find, my lord, according to my lord measurement, 37 decimals to 8450 decimals.
Huh?
According to measurement, my lord, here, my lord, at the last, same serial, my lord, 0.2728450 acres. That measuring, my lord, coming, my lord, 27 decimals, 28450. This is a part of the plot.
0.2728 450 acre.
acre. But decimals. Mal acres is malot in the same page, malot, the last column. 0.2728450 acres. That means malot 27 decimals and out.
20 decimal and not. Very
Yes.
good.
27.
So what is the last column?
Last column malot that the acquisition which to be made for
The area which is proposed to be acquired. And what is the last but one column? The total area of the land. Total area of the plot.
total area of the
Total area.
Total area.
So out of 67 decimal, they propose to acquire 27 decimal and not.
So mal it is mentioned 97 within bracket angsik. The part.
Then what happened?
That what happened, my lord. According to my lord, notice the petitioner made an objection wherein it is directed upon all the parties, all the owners to submit opposition application before the DM. That page 73, that objection has been filed by the petitioner. Page 73, Annexure P9.
Page 72 is the notification.
And 73 is the objection before the district magistrate.
Objection of the writ petitioner.
Yes.
Plot number 97.
97. It was sent.
Ajit Kumar Karok is the writ petitioner.
Yes. Because since the plot has been gifted by his father.
What is the content of the main?
Thereafter, the notice has been served. Again, page 77. It is 3C/1. Earlier notice.
Page number 77.
So, page number 77. Earlier notice was, my lord, under section, my lord, 3A of subsection 1. And this notice, my lord.
Give me a second, sir.
My lord. Page 77. Further notice.
Give me a second, sir.
Paper publication.
এই আর দু একটা ফ্ল্যাপ দেখি ভাই previous notice under 3A
Subsection 1 of section 3A of the National Highways Act.
3A within bracket
1 of the National Highways Act.
And now 77 is
77 is, my lord, under section 3D within bracket 1 and 3D within bracket 2 of the said act, National Highways Act.
3D and 3 due to ধারণ ন্যস্ত ক্ষমতা বলে পশ্চিমবঙ্গ রাজ্যের পশ্চিমবঙ্গ এত জমি অধিগ্রহণের অভিপ্রায় ঘোষণা করিতেছেন. Yes, in the subsequent notice what happened?
But thereafter made objection.
No, in the subsequent notice your land is included.
Yes. My lord, serial number, my lord, 7. The same page.
Serial number
7. Paschim Mendipur, Chandraguna 2, Madan Mohanpur, and my lord, LA case number is there 64. You all have got it. The same line.
64/2223.
Yes. This is my lord, the my lord LA case number. Chandrakona video office.
LA case in respect of plot number 97.
Yes.
Very good. Then what happened?
Thereafter, my lord, I submitted objection and submitted all papers.
Oh, where is your objection?
Well, page 80.
There is a second objection.
Second objection. According to the notice, I submitted all papers. Well, what is happened in this case? Well, according to this last notice, well, kindly turn to page 10. Page 10, paragraph 12. But the BLL row, my lord, called for hearing, and I also present without any notice.
Page number 10.
Page number 10, paragraph 12.
Kindly place, sir.
Well, I'm reading that. Your petitioner states that according to objection filed by the petitioner before the district magistrate and collector Paschim Mendipur dated 19/9/2022, the concerned acquiring body, that is district magistrate, directed the concerned block land and land reforms officer Chandrakona to district Paschim Mendipur for sending a detailed report before him in respect of the petitioner property in question. Next paragraph. As such, by taking into consideration of the direction by the district magistrate, a report was prepared by the local block land and land authority, Chapter 2, which was sent to district magistrate under his office communication number 47/1 dated 21/2023. You got it. Thereafter, no communication, nothing is there, no compensation, but my land has been marked by demarcation.
No, what is paragraph number 13?
13 I'm reading. Your petitioner submits that it is known from the reliable source that the office of the district magistrate and collector that the property of the petitioner having plot number 97 Moja Modanpur is to be utilized by the requiring body for the purpose of national highway. But no compensation is to be paid by the district magistrate and collector to the petitioner for which the petitioner has been compelled to file this writ application. Until without payment
So,
of compensation.
It is your apprehension that it will be
My
utilized.
lord.
Apprehension. It is
So on
my
the basis of the apprehension, what can be done?
what is happened, my lord? In spite of that,
No, you stated on your affidavit, it is known from the reliable source that the office of the district magistrate and collector, that the property of the petitioner having plot number 97 is to be utilized by the requiring body, but no compensation is to be paid. How do you know the about the decision?
that is
My lord, that is the
what,
case.
my lord, what, my lord,
My lord.
my lord, what,
Only
my
on the
lord,
basis of the assumption, my lord, it
my
came
lord,
before your lordship.
my respectful submission, the report already been submitted by the BLLRO under my lord memo number 47/1 dated 21/2020.
What is your prayer then?
My lord, prayer, my lord, kindly turn.
Compensation, lordship, to grant compensation.
My lord, only I know, my lord, I only want the part compensation. They may utilize.
Show me that it has been utilized. What is the document?
My lord, don't.
My lord, my lord, in this case, my lord, the land has been vested with the National Highways Authority free from all encumbrances, my lord. After that, my lord, the next procedure is, lordship, the disbursement of the compensation, my lord. My lord, that is, my lord, maybe the Kala, my competent authority is the answering respondent, my lord. If, my lord, he is entitled, he will get the compensation because, lordship, in my 3D notification, because my learned friend only annexed the paper publication, my lord. This is the 3D.
National Highways একটা দেখি তো ভাই।
My lord, this is the entire 3D notification.
My lord,
We have.
yes, okay.
National Highways একটা দিন। Yes, madam.
My lord, the land has been acquired under
National Highways Act.
হিন্দি দেখুন সবই সাথে তারপরে আবার এটা আছে আপনি তো সম্পূর্ণ অ্যাজাম্পশনই করে ফেলেছেন আরে আপনি শুরু হয়ে কম্পেনসেশন দিলেন পাবেন না মানে এন্টাইটেল কমপ্লিট করুন
West Bengal Highways Act, National Highways Act. ওগুলো ওর কাছ থেকে বইতে পারবো।
My lord, this is my lord. এটা দিন তো। My lord, kindly excuse me, this is marked, my lord, that section.
No, it's all right.
C and 3D.
Yes, madam.
My lord, this subject plot, my lord, has been acquired by section 3A of this notification.
Huh? Section
3A, my lord.
yes.
The notification, my lord, that is 16th August 2022. My lord, this is the entire notification, my lord, including the subject plot. My lord, this is the 3A notification. My lord. After that, my lord, it has been published in the Gazette notification as per section 3D.
That is at page number.
My lord, that is, my lord, enter documents is section 3A.
No, page number 77 is the 3D.
My lord, that is the that enter thing.
3D, yes.
My lord,
3D 1 2.
My lord, 3D, my lord, this is the entire 3D documents, my lord. The Gazette notification, including the plot of the petitioner.
Then
Now, my lord, my lord, what is the
Huh.
my lord, what is my understanding after perusing this writ petition, my lord, the learned free is only on the basis of the presumption that his land may be treated as a government land, so he is not in a position, so he is not being given any compensation. It is only on the basis of assumption. But my lord, in the rate report prepared by the district magistrate, where it has been clearly mentioned, the plot has been in twofold, my lord. One portion is government, and other portion is private, my lord. If that part is come within his jurisdiction, my lord, he is entitled the compensation. My lord,
No, the competent authority will determine the compensation.
my lord, entire thing, my lord, is
The
only
district
on the
magistrate.
basis of the assumption, my lord, he not been lordship, he may not receive the compensation on the basis of only
Why my
assumption.
land has been demarcated? This is my question. This is not the
On
assumption.
on the basis of the for the
Demarcated
public
by
purpose,
pillar.
for
This is
public
not a
purpose.
malad case that petitioner malad only
Lordship.
malad.
No, what is your report?
My lord,
What is your instruction?
my lord, my instruction is regarding lordship. The land has been vested with the National Highways Authority, my lord. And after part the compensation, my lord, the entire compensation amount will have been deposited before the competent authority, and competent authority will judge whether he is entitled to give this receive this compensation or not, my lord. The disbursement authority is the lordship, the competent authority, the state. And my lord, in my 3D notification, my lord, page 77.
Mr. Dev, what is your instruction?
Yes.
The vesting order is now said to us that is a competent not addition now competent authority will dispose of the objection and will consider the money to get the money.
In accordance with the provision of section 3G.
My lord.
Yes.
And if you are, so let them, let me do one thing.
Premature, my lord.
Directing the competent authority to dispose of in accordance with the provision of section 3G.
My lord.
That is the provision.
My lord, this is my submission. It is a premature petition, my lord. Because
How?
Yes.
Why my land has been demarcated by pillar? Why presumption?
No, he is entitled.
Why demarcated by pillar?
If he is entitled,
বললেন
Why demarcated?
আমার বই আনানোর ব্যবস্থা করুন ন্যাশনাল হাইওয়েজ কোথায় চলে যায় এখান থেকে টাইপে কাছে কোনো ম্যাটার হয়নি বাজি কথা বলে কোনো লাভ নেই আসুন 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 The affidavit of service as filed today on behalf of the writ petitioner is taken on record. Stop para. At the time of hearing, learned advocate appearing on behalf of the writ petitioner at the very outset draws attention of this court to paragraph number 2 of the instant writ petition, wherein it has been stated that in plot number 97 Mauja Modan Mohanpur, the writ petitioner is the owner of 62 decimals of land by virtue of a deed of gift dated 23/9/1976 as executed in favor of the writ petitioner by his father. Stop. At this juncture, learned advocate for the writ petitioner draws attention of this court
And I am for the private respondent.
পাওয়া গেল আমাদের আগের বইটা কি হলো দিন 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 What is the service?
Well, the affidavit of
Service has been affected upon the private respondent.
Yes, I am appearing.
Oh, I'm sorry. You are appearing with the private respondents.
Yes, no, other day also I appeared. Your Lordship is pleased to direct the petitioner to serve upon the state. Mr. Mukherjee is there.
Yes. What is your contention?
Yes, my lord. My lord, the petitioner and the private respondents are co-owners of a plot of land, my lord. My lord, the private respondents, by occupying illegally a non-Julie land, my lord, they are constructing a building, and that's affecting, my lord, my ingress and egress to my property, my lord. I preferred one representation, my lord, at page 23, marked as Annexure P2.
Page number?
Page number 23, my lord.
Kudi.
Sir, P2.
Search kori.
Such representation was given to whom?
Given to, my lord, the executive engineer, PWD roads, the district magistrate, the BL and LRO.
Executive engineer PW roads.
Yes, my lord.
And where is the, who is the BL? Where is the BLRO?
Uh,
You have made the BLRO party.
my lord, the BLRO here.
Then
No, my lord, the BLRO is not the party here.
Krishnaganj.
No, my lord, the BLRO is not party here.
BLRO, the jurisdictional BLRO is BLRO Krishnaganj.
BLRO Krishna, my lord. Krishna Gonj. Yes, Krishna Gonj.
Mr. Mukherjee, let him consider the representation.
Subject to correction. And I have taken a plea other day regarding maintainability of the writ petition on the basis of the petitioner alleging his encroachment in respect of the highway. Subject to correction by your lordship. He cannot maintain the writ, being an individual. For encroachment, not the land of the petitioner itself. He is not the person interested. Kindly see the law itself. Section 10(1).
বইটা ওদিকে চলে গেল কেন কল্যাণ বাবু বইটা আপনি আমাকে মামলা করতে দেওয়ার ইচ্ছে নেই মনে হচ্ছে ন্যাশনাল হাইওয়ে নিয়ে নিচ্ছেন ওয়েস্ট বেঙ্গল হাইওয়ে এক কাছে ছিল সেটাকে দূরে পাঠিয়ে দিচ্ছেন হ্যাঁ হোয়াট ইজ গোয়িং অন আপনি চান না কাজ করি
Public interest litigation.
Yes, correct. Mr. Mukherjee is correct.
Yes.
Kindly take 10(1). May I read for you? If any person is found to have made an encroachment on any road, street, path, way of land which is declared but to be a highway under subsection makes an encroachment. Allegedly, I have made the encroachment on a highway in contravention of the section 8. Does not remove the encroachment on the expiry of the cancellation or any permit granted to him. If granted, then after expiry, then the highway authority or any officer by him in this behalf shall serve a notice on him, requiring him to remove the encroachment to restore the highway in its original condition within the specified in that notice. If the encroachment is not removed within such and such, then it is the authority of highway whose land I have encroached. It is their duty to remove all these things, not personal.
On account of their inaction, what can be done?
But for that reason, he cannot, because it is not his land, but that portion, that plea has been upheld by the division bench of our High Court. That is what I have taken note of that. Kindly see the division bench. It is by way of appeal, it could have been. And that there should not be any allegation regarding of encroachment of one individual. If there are an encroachment in on a public road in several persons, all the persons to be removed, not the one. It is a personal grievance that encroachment in that. Second page, last but one paragraph. The Honorable Division Bench held such order, in our considered view, cannot be passed in such a writ. Got it? The word such relief was claimed by the writ petition. It is not the writ petition in the nature of public interest litigation. Therefore, the writ court cannot entertain this.
Writ petition is not
Maintainable. নাম দিয়ে দাও। No, on it. An amendment in paragraph 3.
several private respondents.
He has to file a
My lord, may I just one thing, my lord?
Yeah.
My lord, in this case,
Listen to my order.
This is my application before you.
For Union of India, my
Round of litigation.
Give me a second, Mr. Sanam. You have prayed for writ of mandamus or writ of prohibition? Mr. Sanon, would it not be proper to issue appropriate writ in the nature of writ of prohibition?
Prohibition can be also, but prohibition
place
is
your
temporary.
case.
No, this is, I've got a plot of land that is about 8 bighas. Now, but on that, I have a liquor shop, I have my dwelling house, and some agricultural land. The NHAI, they published an advertisement in the newspapers and also in the Gazette that they would acquire a portion of my land. Now, the acquisition proceeding, I have no doubt, I have no quarrels against this acquisition proceeding. It has paired my land into two, like an egg which is paired in the middle, and the contents are taken off. Now, I've been left with two shells where I can't even do anything.
You are the owners of the 8 bighas of land
Yes.
In plot number such and such, where it has been mentioned in paragraph number 2.
Yes.
Now the NHAI authority has published a notification.
Yeah.
Then what happened?
Now, after that, I made a representation. They heard me and they said, no, we can't change the alignment of this. I said, either you take
You
my
made
whole land.
representation for what reason? Not to acquire.
No, I said, you either acquire the whole land or you please change the alignment so that I can at least utilize my lands, which are left over. You're leaving with me with two shells, with nothing inside.
No, the NHAI authority find some think that this land will be required while they will acquire the another land.
No, it's all in it's 8 bighas. This is an 8 bigha land.
Mr. Sandal, try to visualize what I intend to say. Suppose NHAI authority intends to acquire this land for public purpose. You say you don't acquire this, you acquire this.
No, you acquire it.
Yes.
I say you acquire the whole thing. Take the whole thing. But don't bear it.
How do you say that?
Because of the fact that what land I'll be left with will not be utilized at all. Your Lordship sees 100 feet of land or maybe 200.
No, it is their discretion. How much
I
amount
should
and
be
where I will acquire.
I should be heard. My main point is that
The National Highway Authority,
proper
National Highways Act provides so.
Yes.
So
there
is
it
the
is.
release.
Now they have to, and there is also the doctrine of proportionality.
You place paragraph number 3. Sir.
Now, if your Lordship sees.
No, you place paragraph number 3. The measurement revealed that the petitioner's land would be bifurcated in such a way that the land left after acquisition would be rendered useless for any other purpose. So this is your main grievance.
Yes. And that's why I wanted to hear
noticing such alignment petitioner by representation not to amend the alignment.
Yes.
Show me the relevant law.
Now,
by which law it can be done.
I'll tell you, Lordship. A hearing is a must. Number one. A proper hearing into my complaint. Number one. Number two is the doctrine of proportionality. Now, you cannot take a sledgehammer to crack a nut. Now, that's the other point I take.
Sir,
if your Lordship sees.
National Highway Authority has got any enmity with you?
No.
It is for public purpose.
Yes. But public.
So they will decide where to acquire and how much to acquire. How do you say that?
But I have a right of hearing.
But very good. Show me the law that they cannot
Your
acquire in
Lordship-
this person.
Your Lordship will kindly take the hearing, which the recent order which they have passed. Your Lordship will kindly come to page 43, 45, 46.
So show me your representation first.
My representation. Then after that, I came to this court.
No, show me your
Yes,
representation.
yes. I came to this.
I
honorable
want to
court
see your
on
representation.
Page, page 33. Before that, page 33 was the page 16.
Page?
16. Page 16.
No, I want to see your
Starts from
representation.
page 16.
1/6.
Yes, 1/6. Thereafter,
Give me a second. Give me a second. উক্ত বিষয়ে নোটিশ প্রদান করা হয়নি এটসেট্রা এটসেট্রা হলো
page 20.
কোনো ক্ষতি এমনকি
On page 23, I made separate representations to everybody.
মানে ইওর কন্টেনশন এনএইচআই এর প্রস্তাবিত নকশা বাদ দিয়া আমার দ্বারা প্রস্তাবিত নকশা অনুযায়ী যদি এনএইচআই এ জমি গদিন করেন তাহলে আমার সম্পত্তি সঠিকভাবে রক্ষা করতে পারবো।
It will not be an alignment, Millard.
Show me the relevant law
I'll tell you, Lordship.
that for the purpose of to suit your purpose, the NHI, the authorities, are duty bound.
Suiting my purpose, it's only 7 feet here and there. It's only 7 feet. 7 feet alignment this side or that side. 6 feet or 7 feet. That'll save my land.
Sir,
I'm not asking for an
can I say that Howrah Bridge be shifted to Bagbajar area?
No, that's not the thing. But my point is something.
Or it be shifted to Sojnekhali?
My point is something different, Millard. They have to consider my application. What have they done?
No, there must be some
Whether they
basis
do
in
it,
your representation.
whether they do it or not, that is their discretion. But I have a valuable right of being heard at the right time, in accordance with the law.
So,
Yes,
show me the
that
law.
I
I
will
want
show
to
you,
see the law.
That's what I'll show you, Lordship. Now, if your Lordship kindly comes to page.
No, you have made a representation for shifting of the alignment of
No,
the
Millard,
proposed
If
acquisition.
your Lordship sees.
Where is that provision?
Yes, if your Lordship sees this, that doesn't mean that you just take away my right to hear. Right of
But
hearing.
it is for a
that's
public purpose. You are entitled to
Maybe,
get
but that does not
just
override.
compensation has to be assessed
That
by the
will
authority.
not override the provisions of natural justice.
Show me the law.
Yes, I will show your Lordship. Your Lordship will kindly come to page 46. Page 46.
Your হয় নাকি রে বাবা?
It might be an absurd proposition, but still, the right is a constitutional right. That's what the Supreme Court says.
My lord, before my lordship, my learned friend start.
Please, I'm in.
Okay, my lord, what my learned friend is relying upon, my lord, that order has not been challenged in this writ petition, my lord. This order has not been in his prayer portion, my lord.
Let me see.
My
What
lord,
why-
but this
Your
order
Lordship
has
will
not been
kindly-
challenged. my lord.
Your Lordship will kindly see this. Page 46. Round sir, Page 40. Round sir. Now your Lordship will see. LA case number so and so not acquired. Is not acquired. And thereafter, regarding the change of proposed alignment within
Which portion, sir? Which portion?
5.
Place the entire paragraph.
Yes. Should I read the whole page? The CR is put up today for
No. Read the paragraph number 5 from beginning.
You know, whole page is well necessary, Millard. Your Lordship.
You will place.
Now, LA case number LA NH 62. That's I'm reading from 22. From 1. Name of the project: Kharagpur, Bardhaman, Morgram Economic Corridor Project, NH so and so. LA case number so and so. Suit plots number so and so. And this is not required. Okay, fine. Mauza Padua. So, prayer of the petitioner claiming for change of alignment of the Kharagpur, Madhbara, project within the suit plot in Moza so and so. Before issuance of notice to all the interested parties, valuable
Sir,
opinion.
paragraph number 5, read to kindly.
That is what I'm reading. Before issuance of notices to all the interested parties, valuable opinion of GM Tech and Project Director NH116A, Project Implementation Unit, Kharagpur NHAI Complex, regarding the change of proposed alignment within the petitioner's land of Moza so and so, Chandrakona was sought for vide. This office memo number so and so. Now, this office received the valuable opinion from the GM Tech and Project Director, Project Implementation Unit, Kharagpur NHAI Complex, on 15/3/2023 with a reference number so and so, dated 23/10/2022, dated 1/2/2023. It is clearly stated that the alignment of the Kharagpur Bardhaman Morgram EC project has been finalized by the Ministry of Road Transport and Highways, Government of India, with a 51st meeting of LA Committee held on 16/8/2021. And also the state government, West Bengal, has given consent to
Mr.
the
Sanyal,
alignment. Now, no,
your entire your entire effort will be futile.
no,
I'm not inclined to allow this.
no, I'll tell your lordship why, your lordship.
No.
No,
It
your
cannot be
lord-
done.
It
cannot
has
be done.
to be, Millard, your lordship. will
It cannot
see.
be done, sir.
Before they take under 3A,
Everything has been done in accordance with law.
it has not.
It has. It cannot be. It cannot
It
be.
has
entertained.
not
No,
been
sir.
done.
No, sir.
No, your lordship will kindly see. So if your lordship before
There,
your
there
lordship,
cannot be any kindness to entertain in this.
no, there's no kindness. I don't want a kindness. I don't want mercy here.
Sir.
But I want.
Sir, don't insist by this court. Don't insist this
No,
court to
your
pass
lordship
a
will see
pass an
what
order which
happened.
is
They put the cart before the
impermissible in
horse.
the law. Come. No, Mr. Sir, I'm not inclined. Stop, para. By
I
filing
won't
the
even
instant
be able to
petition,
cross over. We learn every day, Millet.
Lordship, here in this matter, Lordship, Mr. Sondipan Banerjee is appearing on behalf of the petitioner, Lordship. Lordship, I'm praying for not this week, Lordship. He's been recently briefed, and for such
23 matters.
Lordship, he just recently briefed, Lordship. Keep it on next Monday, Lordship. He will definitely come.
Not this week. Kola.
Grateful, Lordship.
Sir, motion matter don't seek adjournment. For inclusion of this matter, other persons are being deprived of. I'm to fix certain fixed motion matters, fixed motion, listed motion. If you do not do, other person can get a chance.
Grateful, Lordship.
Your Lordship, I am for the respondent. I am extremely grateful to your Lordship that on the last occasion, your Lordship has been kind enough to give me liberty to place the relevant papers in connection with this matter, where I have pointed out before your Lordship, so far the point of res judicata is concerned. Your Lordship kindly sees the earlier order. Now, I don't know whether
For the petition.
Kindly see this, the order, last order, my lord, kindly see on. I am for the petitioners. My learned friend is appearing for the private.
I will see this order later on.
yes, I have.
Res judicata, my lord, kindly see plot number is the different.
Give me a second.
Petition plot
Give me a
relates
second,
to
sir.
803. Earlier writ petition.
Give me a
plot
second,
number
sir.
relates to
Wait.
800. Yes. Kindly see.
तो तारागुरु करले तो मुश्किल
803.
Mr. Washington.
And report on the basis of that report should be filed
For the state.
by the state. Mr. Osim Ganguly is appearing for the state.
My lord, I have something to submit.
No, on the last occasion you appear
no.
on behalf.
No,
Sir, you cannot shut
we
my
are on the private response.
argument.
you also cannot shut my argument.
What
I am
he's
the
saying,
petitioner.
my lord,
Don't make words.
I asked before your lordship that I have something to submit. I pray the liberty. I have take the endeavors my advocate on record.
Mr. Mitra, please.
My lord, all
keep
the
your
papers
pace.
are there. In this matter, I will beseech your lordship to impose heavy cost.
Give
if
me-
I am
give me a-
successful.
Mr. Mitra, allow me to read, sir. I will hear you.
Mr. Ganguly.
I have been to the doctor now. Sorry for
No, it's all right.
not well, I could not accept that. But I have got the report with me.
Last occasion, your lordship cleared the state to file a report.
But I have got the report.
Yes, what is your case?
My case is that plot number 800. Earlier writ petition, plot number 800. My lord, kindly say I have handed over this order. Writ petition number.
No, what is the in this read petition, what is your read? What is your case?
My
I
lord,
want to say.
We are the recorded owner, and private respondents are forcefully occupying the land which belongs to National Highway. I made a representation to the National Highway.
So how you are aggrieved?
We are facing the difficulties for egress and ingress, the entry to my house. Now, kindly see, I have annexed the record of rights annexed at P1. Kindly see. 803 in respect of plot number 803. And I made a representation.
Plot number 803.
803.
Who is the read petitioner here?
Writ petitioners, my lord, kindly see. That is the Wahidullah Sheikh, Akhtaruজ্জামান, Faimuddin, Moinuddin, Mujibur Rahman.
Your names are appearing.
Yes.
Where from I will get that?
Yes. My lord.
Where from I will get your name?
My lord, kindly see the page 1, my lord, in my cost title, my lord, writ petitioners. One,
Sir,
two.
try to understand what I am saying.
Yes.
In the record of right,
Yes.
your names
Yes,
are
yes. Oh, yes.
transferring.
Yes, my lord.
In respect of plot number 803.
Yes.
Faimuddin.
My lord, the top is 31 and still one, my lord, the top tab number 803. Top.
Yes.
Mauza
Show me.
Patrapur, Jela Pirpur. Top in the right hand, left hand side.
Where your names are appearing.
My names, my lord, kindly see. Kindly see the case 32. Koimuddin Sheikh, Alimuddin Sheikh,
Alimuddin is a writ petitioner.
Yeah, my lord.
Writ petition number?
Writ petition, my lord, kindly see.
Writ petitioner number.
Yes, yes, yes. Moinuddin Sheikh, my lord, 4. Alimuddin, my lord,
Mujibur Rahman. 5. Some names are appearing.
yes. Some, my lord, kindly see.
Very good. Then what happened?
Yes.
Then what happened?
Mujibur Rahman, yes. my
Very
lord.
good. Then what
Then
happened?
I made a representation to the executive engineer, Birbhum Highway Division, my lord, page 34.
Page number?
Page 34 by the demand justice.
Page number 31. No? 34.
Yes. Page 34 starts from page 34. Plot number 803, Mouza Bhadrapur, jail number 90, and my lord, the PS Nolati district. And I handed over to the, before your lordship, my lord, kindly see plot number 800 on in respect of writ petition number 17638 of 2022. They were not the party. My learned friends client were not the party in that writ application. Another party. Petition is the same. Different plots. They are forcefully occupying and they filed a suit.
Let him
It is in front of the land of my clients and also block the egress and ingress of the client.
Yes, yes.
Yes.
But made an inquiry and that if it is
Now tell me
occupied by the land,
what this order sheet says.
my learned friends pointed out on earlier occasion, that is the res judicata. That is the writ petition number, kindly see, and the plot number, kindly see. That is the proceedings initiated 10-3 of the West Bengal Highway Act 1964. But kindly see the plot number 800 of Mouza Bhadrapur, jail number 90. Under the Nolati PS, that is the executive magistrate number.
You'll get your chance.
Yes.
What is this?
Sorry.
Executive magistrate, Rampart subdivision, Rampart bill. Another disposition. And they took steps and removed the.
So it is in respect of plot number 800.
800.
So it is now we are concerned about plot number 803. Very good.
Yes.
Anything more?
No.
Take your seat, sir.
Yes.
Do you want to take a glass of water? Take a glass of water. Mr. Mitra, you are appearing on behalf of whom? Mr. Mitra is appearing on behalf of whom?
10, 11, 12, 14. 10, 11, 12, 14 and 19. 14 to 19. 10, 11 ঠিক বলছো তো? 12, 14 to 19.
Just a minute. Respond number 10,
11,
11,
12,
12,
14
14,
to 19. Onwards, 14, 15, 16, 19.
10, 11, 12, 14, 19. Mr. Mukherjee is appearing?
to 19. I am appearing on 20 to 27.
22 to 27.
27, 29, 30, 30, 35.
29, 30.
Last part. 32, 35.
Just a minute. 29, 30. Then
32, 35.
32 to 35. Or 32 and 35. 32, 35.
38, 40, 41.
40.
41, 43.
43.
And 48.
And 48. They are all private respondents.
Respond number 1 to 9 state.
Respond number. Mr. Ganguly appeared first.
May I submit?
Yes, Mr. Mitra.
Now kindly see, my lord, a copy of the plaint. I am coming one after another. Not a single whisper in the writ petition filed by the petitioner. Now kindly see the copy of the plaint. Now kindly your lordship take the trouble, side by side, kindly place the writ petition, the cost title. Kindly, my lord, place the writ petition. Writ petitioner number, the father of writ petitioner number 1 and 2,
are plaintiff number 2 in the suit. Kindly see. His name is Alimuddin Sheikh, subject to correction. Father of writ petitioner 1 and 2 are PW2 plaintiff number 2. Kindly see.
Alimuddin.
Yes, Alimuddin. Now, my lord, the petitioner number 3 in the writ petition is Faimuddin Sheikh. Your lordship got Faimuddin, writ petitioner number 3, subject to correction from your lordship. Faimuddin Sheikh.
Faimuddin, yes.
Yes, he is plaintiff number 1 in the suit.
Yes.
Now, thereafter, my lord, 4 is Mainuddin Sheikh, writ petitioner.
4 is
Mainuddin Sheikh, writ petitioner. Your lordship got, my lord.
He's plaintiff number 3.
I'm grateful. And Mujibur Rahman is plaintiff number 4. Now,
Rahman,
plaintiff
number 4.
Yes. Now, in the suit, kindly come to the, my lord, schedule portion. That is the last page. Kindly see the DAG number. It is
803.
803. Now, it is not the end of the matter. There is something more. Now, kindly see the earlier page. What they have prayed before the
trial court.
Trial court. আরজি বর্ণিত হেতুবাদে নালিশির ক তফসিল বর্ণিত সম্পত্তিতে বাদীপক্ষ সত্য সাব্যস্ত মতে এবং তাহাতে 1-2 নম্বর বিবাদী পক্ষের কোনরূপ রাইট টাইটেল ইন্টারেস্ট বা খাস দখল এবং 1-2 নম্বর বিবাদী যাহাতে জোরপূর্বক নালিশি তফসিলে এবং সম্পত্তিতে আইনিভাবে কোনরূপ কনস্ট্রাকশন করিতে না পারেন তজ্জন্য বিবাদী পক্ষের বিরুদ্ধে চিরস্থায়ী নিষেধাজ্ঞা ডিগ্রি হয় along with other reliefs. Your lordship got
so suit for declaration and permanent injunction.
Yes, restraining declaration that we have no right title interest in the properties and also restraining us from making any construction in the suit premises. Now, kindly see this order. Judge Sahib to Devendra. He already obtained against my client an order of status quo. And the order is still disposal of the suit. There must be limit to everything. Subject to correction, your lordship will pardon me. Till disposal of the suit.
Where he exceeds the limit, I cannot understand.
In this suit, the plaintiff obtained an order of injunction. And the injunction is still, kindly, I'm placing the injunction order. Last page. Your lordship got, my lord?
Before the trial court,
yes,
over the same plot,
yes,
he is seeking a declaration injunction.
Absolutely.
What is the nature of declaration, Mr. Mitra? That he is the absolute owner?
Yes.
And what is the nature of injunction sought for? Permanent injunction, restraining your clients from interfering with their peaceful possession.
I go down.
So how it relates with
I'm
this?
coming to that. Your lordship,
yes.
Hear me. Now, in the injunction, he got the order that the instant petition I have handed to your lordship under order 39 rule 1 and 2 read with section 151 of CPC is hereby considered and allowed. Accordingly, plaintiffs and defendants number 1 and 2 amra 1 and 2 to defendant yes we are 1 and 2 are hereby directed to maintain status quo as regards to the nature, character and possession of the suit property till the disposal of the suit. Not a single whisper, your lordship, in the writ petition. Suit has been filed by him.
Why it is necessary, Mr. Mitra?
I'm coming to that. Your lordship, kindly bear me.
Please come.
I'm coming. My lord, in the suit, he has stated that he is the owner of the property. In the writ petition, he is saying that the land relates to PWD.
His case is that
yes,
because of your illegal encroachment,
yes,
because of your alleged illegal encroachment,
yes,
over the PWD land,
yes,
he is not getting access to his property.
My lord, when the
suit is distinguishable, Mr. Mitra.
My lord, I join issue with your lordship. When the suit is pending over the self-same cause of action, my lord, your lordship kindly.
I got your point.
No, I have not completed. Yes. I have not completed. Your lordship kindly comes to the prayer. No decimal has been mentioned. If I am not wrong, kindly come to the prayer of his writ petition, my lord.
Your lordship is sitting, my lord, in the highest judiciary of this state. My lord, your lordship kindly appreciate such type of writ petition. My lord, kindly see if I am not wrong. A writ in the nature of mandamus, page 27, commending the respondents, their assignees, particularly to remove the
Had you
encroach.
been in the other side, you also come forward with a similar prayer.
My lord, here is no mention of, my lord, the decimal.
Yes, Mr. Ganguly.
And my lord, there is something more. My lord, only 1 minute. I have not completed. My lord, kindly.
Yes, sir.
Your lordship is so kind enough. I have stated on the last occasion, my lord, this is the earlier writ, self-same cause of action. What my learned friend has given your lordship is not the same. Self-same cause of action.
What order has been passed?
May I place the relevant part of the order? Record reveals that is inner page 2. Record reveals that the petitioners have already prepared a title suit which I handed to your lordship. Right? 3 of 2016 before the competent civil forum, and an order to maintain status quo as regards nature, character, and possession of the suit, being the property detailed in paragraph 5. Now, your lordship, kind to the next page. Petition has been passed till the disposal of the suit. It also appears in the said suit the respondent number 4 is also a defendant. The competent forum is thus in ceasing over the dispute between the petitioners and the private respondents. Accordingly, the writ petition is disposed of with the liberty to the petitioner to take appropriate steps in the pending title suit. Now, kindly see the prayer portion of this earlier writ petition. Page 20. I have handed to you, your lordship, the certified copy. May I place? This has been wrongly typed as 83. It is 803, as your lordship will get inside the writ petition. Kindly see the prayer. A writ in the nature of mandamus commending the respondent, their main agents and subordinate in office, including the police authorities, to showcase as to why the unauthorized construction and illegal encroachment on the PWD vacant land of state highway situated as such and such. Now, this is wrongly typed. Your lordship, kindly see the
Page number 5 is there.
Yes. So, my lord, same writ petition.
Then,
No, I mean,
in an earlier writ petition, and your prayer was not considered. How can I prepare an appeal, prepare a second writ petition?
No, I referred this matter on the basis of that plot number 800. 800. This plot number 800.
No, 803, paragraph
Kindly see,
5, page 6 of the same writ petition, your lordship sees. No, kindly let me.
No, WP number. No, I've asked you. Why are you asking?
Sorry.
Please. In WP number 13933, within bracket W of 2018, you have made identical prayer.
Identical prayer in respect of plot number 800 on WPA number 17683 of 2022.
That is different. That is different. This is 18. My learned friend is showing something a different writ petition. That is the difference.
On the basis of that, my lord, the
No.
No. What no? I am submitting the records. My proceedings under section 10(3) of the West Bengal National Highway Act, 1960.
National Highway or West Bengal Highway?
My lord, West Bengal Highway.
Hey, you can look at it.
This is passed by Justice Chakraborty. This is a different writ petition.
I need look to the first flag. I have marked. First flag, yellow color.
Flag,
sir. I do not. I have no. I have no knowledge.
Then it is bad.
I have no knowledge. Yes, that is. I'm.
Yeah, kindly check, sir.
Yes.
Whether your clients are prepared.
Yes. In this point, my lord, I must fear, my lord. I am not that, so I cannot say that.
Asun.
My lord, kindly. No, plot number 83.
That is typographical mistake. Para 5, it has been mentioned.
Kindly see.
It is this, the tag is the lower bottom portion, Rashid.
In which portion of your writ petition you have stated so? Show me the relevant paragraph. That on such and such day you have filed and no date has been, no number has been given.
Paragraph 49, Lordship.
Preferred an appeal, 10-4, which was received but no number was allotted. A preferring appeal made an application. So in the event this order is implemented, your appeal would become infructuous. What is your prayer then? Not to act upon the other till disposal of the appeal. Yes, Mr. Pan.
No, my lord, only thing I am praying before Lordship, my lord, it cuts out the matter. Kindly direct the district magistrate to dispose of the appeal.
Absolutely, that I'm-
Because of the, I tell you, Lordship, this is a long pending proceeding. My lord, merit of this case is this.
No, within a time bound.
Within a time bound, because the claim is based on a post-vesting purchasing.
Very
I,
good.
I,
Whatever
I will agitate all these points, my lord. Kindly
I'm
dispose of this.
directing all concerned to appear before the district magistrate on a particular day, and I'm also directing the district magistrate to dispose of the appeal within a specified time.
My lord,
Mr. Bandyopadhyay,
without granting any adjournment whatsoever in nature.
stop. At the time of hearing, your good name, sir? Mr. Das, learned advocate, appearing on behalf of the writ petitioner, at the very outset draws attention of this court to page number 1 appear before him.
Parties will
ঠিক আছে।
27.
My lord. Yes, 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 yes.
Head for lordship.
Get
For the petitioner, my lord, item number 47 and 51. I appear for the Madrasa Service Commission in all the matters. And the lead matter is supposed to be, as Lordship indicated, WPA 24588. If any additional point is required to be submitted,
Absolutely, absolutely.
then my lord,
It will be a lead matter, otherwise I will
yes,
take
yes,
up.
yes. Grateful, my lord.
Item number 52, my lord, I have that completely different matter from my.
You are supporting the madrasa.
If I
Supporting, I have a different cause of action, but yes,
It will be taken care of. sir.
regarding additional point, we have some additional.
not additional point. I have a point regarding.
All point will be take care.
And there is a can which is kind of filed along with their matter.
Yes, yes.
Huh? As এখানে স্যার আমি তো আদার সাইড ও তোমাদেরকে লিড করছেন না দ্যাটস গুড
17.
অনিন্দ
Who will argue this case? Where is he? You start.
I understand that this will continue.
Yes.
Deep development. Deep development.
কোথায় আছে এটা তো ফিক্স ছিল কোথায় চলে গেল
My item 44 is the my Onindo Bosch. There are 45 petitioners before my lord. In item 44, my lord, is a lead matter, my lord. But
Item number 44.
yes, my lord, WPA 24588 of 2024.
24588 of 2024.
My lord,
Where the subject matter of challenge is the notice dated 5/8/2024
5824,
and notice dated 9/8/2024.
9th August 2024.
Very good. Make your submission.
My lord, there are 45 writ petitioners before my lord, who had participated in past state level selection test non-teaching 2010 for the post of Group D staff. My lord, the petitioner appeared in the preliminary examination, which were held, my lord, in 3 phases, my lord. In session 1, that is from 11 AM to 12 PM. Session 2, my lord, from 1 PM to 2 PM. Thereafter, my lord, as session 3, my lord, 3 PM to 4 PM. Which was held on, my lord, 28 November 2010, my lord.
Date is?
But 28 November 2010.
Yes.
Thereafter, my lord, on the basis of the preliminary examination, my lord, written examination was conducted by the commission on 29th May 2011, where all the
So 28/11/2010 is a screening test.
preliminary
Preliminary exam.
screening test.
Give me a second. What is the name of the second phase of examination?
My lord, the written test, my lord.
Date?
My lord, on 29th May 2011.
29th May 2011. Very good.
My lord. Thereafter, my lord, after my lord, the written examination, my lord, since the evaluation of the answer script in respect of written examination was not been done, a writ petition was taken out at the instance of Sri Shoumen Malakar before this honorable court. But the WPA my lord 1722 of 2018 my lord, wherein my lord an order was passed.
That is at page number 64.
64 my lord. My lord, may I read for lordship my lord? But Mr. Devan, learned advocate, appearing with
Come to the 65 second paragraph.
No, my lord, one thing. My lord, here, my lord, in the report, my lord, may I read for lord? In the report, the reason for not publishing the result of the written test has been given as follows: that the result of the written examination of first state level selection test non-teaching group D is yet to be published, as instruction has been sought by the West Bengal Madrasa Service Commission from Minority Affairs and Madrasa Education Department, Government of West Bengal in the matter, and the Minority Affairs and Madrasa Education Department, Government of West Bengal did not give any instruction to the commission.
So commission has sought for an instruction from the department.
Yes,
and the department has not given instruction.
Instruction.
That report was furnished before the single bench.
Before the honorable coordinate bench, my lord. My lord, thereafter, my lord, the honorable coordinate bench has held that since in terms of the rule 17, it does not provide that it is mandatory. It is not
Instructions
required.
are required.
Not required as per the recruitment rules.
Rule 17 does not show that whenever a written test has been held, such instructions are required.
Required, my lord. And accordingly, the present writ petition is disposed of on or of after recording that writ petitioner did appear in the examination of first state level selection test Group D on May 29, 2011 and not March 27, 2011 as submitted by both the learned advocate for the petitioner and Mr. Diwan, learned advocate for the commission, and by directing the respondent number 2 and 3 to forthwith intimate to the petitioner the result of the evaluation on the answer scripts, and if he is qualified, then to prepare the panel in terms of Rule 18 of the said rules, and he is eligible as qualified candidate in terms of such list of candidates, then the said respondent shall issue invitation letter to him for personality test in terms of Rule 19. No instruction will be required from the state of West Bengal for completing this exercise. But the report is required, my lord. But it is for I shall place before my lord. This report is my lord, the required, my lord. Since they have taken this point before the honorable coordinate bench, that since the state government did not provide the instruction, my lord, they did not publish the result of the written examination. But in the comprehensive affidavit, my lord, they have taken a different stand. That's why, my lord, this report is, my lord, is important, my lord.
In the comprehensive
They have
affidavit,
taken
as used in here.
Yeah, my lord, they have taken a different stand. That's why, my lord, this report is. But since they cannot take a different stand in the before the honorable coordinate bench, they have stated, my lord, that since the state has, my lord, did not give any, my lord, the instruction, my lord, they did not publish the.
So according to him, they were awaiting for the written instruction from the department.
But in the affidavit, my lord, they have taken a different stand. That's why.
Which affidavit?
But they presently they have which they have
composite affidavit as
yes,
in connection with the instant writ petition.
Yes. No instruction will be required from the state of West Bengal for completing this exercise. The entire exercise as aforesaid shall be completed.
That is the finding of the coordinate bench.
No
instruction is required.
Yes, my lord, but the stand taken by the commission, kindly appreciate, my lord. They have taken the stand taken by the commission, and the report was filed that since the state government did not provide them the instruction, they did not publish the.
I understand, but as per the order of the honorable single bench, there is a coordinate bench. The coordinate bench holds that no such instruction is required. And therefore you publish the result by such and
Mal
such.
kindly appreciate, Mal, I am making this submission on the ground, my lord, since they have taken a stand that since the state government did not give them permission, they did not publish the result of the written examination. But they have taken a different stand in the affidavit that there's something, my lord, that since, my lord, the session 1 and session the preliminary examination in respect of session 1 and session 3 was held by considering the answer sheet of session 2. That's why, my lord, they did not publish the result of the written examination. That is a different stand, my lord. That's why.
We'll consider that.
Yes.
Very good.
But the challenging, my lord, that, my lord, the commission, my lord, has preferred the intra-court writ appeal before the honorable division bench, page 67.
They never took the stand. The fresh examination has to be taken at any point of time, in which they have never taken that stand. Normal intra-court appeal. After 8 applications and the 8
Yes.
My lord, the intra-court writ appeal, my lord, page 67 is the order passed by, my lord, the honorable division bench. My lord, the challenge to the impugned order was made on multiple grounds, but on the last occasion, leave was sought by the appellant.
You said that you were led by Mr. Mojumdar.
Yes, my lord.
Mr. Mojumdar, where is Mr. Mojumdar?
He is just coming, my lord.
But I will not allow Mr. Mojumdar to argue which you have argued.
No. He shall make additional submission.
If you think that he will consume such time,
no.
That I will not allow.
No. Thank you.
What happened?
Yes,
Bhattacharya? Your look is so frightened. It's making me frightened.
No.
Yes, sir.
Yes, my lord. My lord, the writ petition was filed by the respondent, one, assailing the inaction on the part of that was recorded that is yet to be published, and the reason for non-publication was shown as lack of instruction from the Minority Affairs and Madrasa.
You are reading from which portion, sir?
Second paragraph, last line, my lord.
Yes. Kindly place.
My lord, the writ petition was filed by the respondent number 1, assailing the inaction on the part
Respondent number 1 is the Madrasa Commission.
Madrasa Commission.
Yes.
Assailing the inaction on the part of the West Bengal Madrasa Service Commission in publishing the result of the written test. The report was called for, and it was opined by the commission that the written examination of the first state level selection test non-teaching group T is yet to be published, and the reason for non-publication was shown as lack of instruction from the Minority Affairs and Madrasa Education Department, Government of West Bengal.
Mr. Mojumdar has come.
Yes,
Your lordship had your lordship.
Mr. Ghosh has stated that the writ petitioners were participating in the preliminary examination as held on 28/11/2010. He also argued that the petitioner participated in the written test as held on 29/5/2011. He also referred the learned coordinate bench order as is available at page number 64 to 66. Now he is placing the division bench order. Now you take the battle.
Your lordship's interim order probably crystallizes the issue. Please have a look at the interim order passed by your lordship. মহা মুশকিল তোমাদের
এই অর্ডার শিটটা দেখি ভাই
তিনবার পরে জানি নাকি প্রচন্ড কষ্ট
My order passed it during last puja vacation.
Yes.
Order dated, sir?
14th October 20.
14th of passed in connection with?
But in this petition.
No.
Abdul Latif. Abdul Latif is 14th October 2024. With Habib Mondol and all this.
14th October. फोर्टीन অক্টোবর তো মামলার এখানে অর্ডার শিট নেই করলেন 14th অক্টোবর অর্ডারটা it was passed in connection with
this was passed in connection with WPA 25438 Abdul Latif and others versus state with Muhammad Habib
25438
yes ma'am
ওইটা পার করুন তাহলে ওইখানে হয়তো থাকতে পারে
তিনবার বলেছি আলাদা করে রাখতে একসঙ্গে থাকলে সুবিধা।
অর্ডার বুক গুলো আলাদা করবেন। না এটা নেই। ঠিক আছে, ঠিক আছে, পরে পরে পরে।
Has your lordship kindly got that?
Give me a second. Yes.
By filing the instant writ petition,
Oh, you appeared on that day. You appeared, I believe.
the writ petitioners have challenged the legality, validity, and correctness of memo dated 5th August 2024, as published by the West Bengal Madrasa Service Commission, whereby and whereunder 73,978 candidates have been asked to participate in the written test scheduled to be held on September 1, 2024 for selection of successful candidates in first SLST non-teaching Group D. Learned advocate appearing for the writ petitioners at the very outset draws attention of this court to an order of 23rd July 2018 passed by a coordinate bench in Shoumen Malakar. Attention of this court is also drawn to the order dated February 4, 2020 passed by a division bench of this court in mat number so and so. There's the Madrasa Commission's appellate order which Mr. Bose has placed before your lordship. It is submitted that the order of the learned single bench dated July 23rd, 2018 was assailed before the division bench in mat number 907 of 2018, whereby and wherein the division bench by its order dated February 4, 2020, while disposing of the said writ appeal and while rejecting the said interlocutory application, did not grant permission to the West Bengal Madrasa Commission to take further written test in respect of the said examination. That's my submission. It is also submitted that the impugned notice dated 5th August 2024 is contrary to the spirit of the order of the division bench and that the same is required to be stayed. While opposing such contention, learned advocate for the West Bengal Madrasa Service Commission submits before this court that the present writ petitioners being unsuccessful candidates have no locus standi to challenge the said notification of August 5, 2024. That's the first objection. It is further submitted that in the previous round of litigations, the present writ petitioners were not the parties and therefore they cannot take advantage of the order passed by the division bench. Now, this is something which your lordship will kindly consider, keeping in mind that it's a question of finalization of a process. It is also submitted, that's the learned counsel for the commission, that pursuant to the said notification, written examination has already been conducted and the merit list has already been published in respect of the successful candidates. On perusal of the entire materials placed before this court, and after hearing learned counsel for the contending parties, it is not in dispute that the subject matter of the instant litigation and the subject of the earlier round of litigations is identical, which is with regard to the recruitment examination of the first SLST Group D. In course of hearing, learned advocate for the commission made an attempt to distinguish the facts of the instant case with the facts involved in the earlier round of litigations. Since in the earlier round of litigations, the writ petitioner is different from the present writ petitioners. From the order of July 23rd, 2018 passed by the coordinate bench in WP 2018 and the order dated February 4, 2020 passed by the division bench in Mat so and of 2018, it appears to this court, at least prima facie, that in course of the earlier round of litigations on behalf of the Madrasa Commission, an application was filed for extension of time to complete the recruitment process, and in disposing of the said application along with the said appeal, the division bench took the following view. We would have proceeded to reject the said application, but considering the plight of the candidates who have participated in the written examination and because of the careless conduct of the authorities, their fate is still in large or in other words uncertain. We feel that the authorities must act strictly in terms of the order passed by the single bench as affirmed by the division bench. We are unable to comprehend the stand of the appellant that further written test is required to be conducted. when the same was not accepted by the single bench as well as the division bench, and the direction was plain and simple that after conducting the written examination, the answer scripts are to be evaluated and the panel is required to be prepared indicating the successful candidates. On perusal of the aforementioned order, it thus appears to this court while disposing of the said appeal that the division bench did not permit the commission to conduct further written test in respect of the aforementioned recruitment examination. Admittedly, the present petitioners were not the writ petitioners in the earlier round of litigations. By taking advantage of the same, in considered view of this court, the commission cannot be permitted to take any further written examination in respect of the aforementioned examination, which was sought to be done by issuing the letter dated August 5, 2024, and which is under challenge before this court. It is submitted at the bar that in the meantime, the written test has already been conducted and the list has been published with regard to the successful candidates in the written test held on September 1, 2024. Such being the position, this court considers that the petitioners are successful in making out the prima facie case for obtaining an order of stay. This court further considers that in the event the stay order as prayed for is not passed, the writ petitioners may suffer irreparable loss and injury, especially when the balance of convenience is in favor of the writ petitioners. In view of such, the commissioner is hereby directed not to proceed any further pursuant to the notice of August 5, 2024 till so and so date or until further order whichever is earlier. The writ petition is required to be heard on merits, then not directions for exchange of affidavits. So, two things were addressed at the interim stage. One, whether at our instance the writ petition could be maintained, and number two, whether the situation warranted taking of a second examination, and apropos the observation or not the intent of the order passed by the Honorable Division Bench. But according to us, not the Division Bench order has sealed the fate of the commission in taking a second examination. Not in not same process, not came to be considered at the interim stage by our coordinate bench.
The final hearing of a matter, the interim order is not to be seen, not to be placed.
Your lordships will consider not whether
all interim orders will merge with the final order.
Because the interim order, they may march, may not march.
Very
Interim order is not to be
I shall
seen.
consider. Yes.
The law is well settled that even not a judgment which is set aside facts recorded in the order are to be looked into.
I believe this order, upon this order, an application is also filed.
But I'll show the nature of the application.
Yes, yes. For modification of the order, something like that.
In another writ petition, there is an application for.
Yes, yes, I know.
Which restricts the commission stand to 9 seats only. 25th November 2024. The petitioners seek conclusion.
Give me a second.
We have filed an application, Lordship, because this order, after creation of our right, once the right has been acted in our favor, we have filed the application because of this interim order. We were being affected. That's why.
Yes, Mr. Mojunder.
The petitioners seek conclusion of the selection process. Selection process. It appears that the initial written test was held in the year 2011. The said selection process is yet to be concluded. The petitioners pray for conclusion. Learned Senior Counsel representing the commission submits that only counselling process is pending. The Honorable Division Bench in Mat so and so specifically observed that the authority must act strictly in terms of the order passed by the single bench as affirmed by the Honorable Division Bench. It was further observed that the bench is unable to comprehend the stand of the applicant Madrasa that further written test is required to be conducted when the same was not accepted by the Honorable Bench as well as the Honorable Division Bench. The Commission, for some reason or the other, is not concluding the selection process and is contemplating holding further written test in respect of 73,978 candidates. It is in a further writ petition being Abdul Latif, not the order that I placed just now. A coordinate bench video order dated 14th October 2024 restrained the commission from proceeding any further pursuant to the notice of August 5, 2024 till December 13, 2024 or until further order whichever is earlier. As it appears that written examination in connection with the selection process of the year 2010 was taken in the year 2011, it is high time that the final result of the selection after conducting counselling be published by the commission without any further delay. The commission shall proceed to conclude the selection test of the year 2010 without taking any fresh written test in respect of any other candidate in terms of the notice of August 5, 2024.
It is a final order or interim
order? Both are interim orders. Now, commission has come up with two stand. আমাদের অপোজিশনটা দাও আমার বিফটা কোথায় চলে গেল
So, Mr. Moyumdar, what is then prior to go to the commission stand? What is your stand pursuant to the order of the coordinate bench as well as the division bench?
Implement the same.
They have got no authority to take any further examination. That is your contention. Therefore, the subsequent two notices regarding taking of examination, further examination is bad in law.
But that is not under challenge. No examination has been challenged.
Yes,
No,
under
no
challenge.
These are yes. The notice is challenge. If the notice goes, the examination goes.
That is under challenge. That is under challenge. That is the subject matter of the writ petition.
What is the situation? Let us consider the position not very practical. 297 vacancies. Certain number of examinees or candidates had participated in an examination process. A preliminary examination which has to be effectively concluded through publication of a merit list and counselling. That's 2010 examination process, examination held in 2011, concluded till 2024, nothing happens. And parties have to approach the court for expeditious disposal of the selection process. As and when parties approach the court for the purpose of expeditious conclusion of the 2011 examination process, commission hurriedly finds out that no, 12 years back, there might have been some error on our part arising out of a technical error.
Which was not brought to the notice of the earlier division bench.
And this could not have been done. First of all, whether commission has reserved.
So far as what I have gone through, that after passing of the order of the single bench and after passing of the order in the division bench, disposing the appeal and thereafter extending time on the prayer of the commission, has it been ever disclosed to the honorable division bench that on account of subsequent facts as which are subject matter of the instant writ petition, we need further time?
No. The stand taken as it appears from the order of the honorable division bench is give us some time, we shall comply. Comply would mean without taking a further test.
So before the honorable division bench, even after disposal of the appeal and even at the time of file successive applications for extension of time to publish the final result on the basis of the written test as held in the year 2011, the commission never came forward with a plea that certain persons have been left out. Am I correct? It is your content.
But that's the succinct point. Now, effectively, two things surfaced from the stand taken in the comprehensive affidavit in opposition used by Madrasa Commission.
Comprehensive. It has been filed in
connection with Muhammad Habil 24588.
এটা বার করে দাও। এটা রিট পিটিশন আছে।
In the back sheet of Madhurima Sarkar.
এটা আছে নাকি? আমি বলেছি বারবার অর্ডার সিট আলাদা করুন।
আর এই মামলা
ও আচ্ছা আচ্ছা, এইটা কি করে বার করবো? খুলে দাও কাটলেই কেলেঙ্কারি হয়ে যাবে। ওনার মুখটা বারবার বলি আলাদা করতে, করাতে তো হবে, নট নাও, এখন করো না। Yes, Mr. Mujumdar.
Please come to note page 11 of the said opposition. That 1,92,241 candidates applied for first SLST 2010, but only 1,43,303 applicants had participated in the preliminary screening examination. Pausing here for a moment, your lordship remembers that before the honorable division bench, the stand was many candidates had appeared. That there was a specific observation made by the honorable court in that order of the division. I shall once again revert to that. The preliminary screening examination was held in 3 sessions, being session 1, 2, and 3. In session 1, 46,052 candidates. In session 2, 47,643 candidates. And in session 3, 49,608 candidates had participated in the said preliminary screening examination for the post of Group D on 28/11/2010. Out of 1,43,303 candidates who participated in the preliminary screening examination, 26,445 candidates were declared qualified in the written examination. Out of 26,445 candidates, 24,577 candidates had participated in the written examination held on 29th of May 2011.
Out of these 24,507 candidates, one person has approached before the coordinate bench in earlier round of litigation.
Shomen Talukdar was one of them. Malakar, I'm sorry, Shomen Malakar. That after the written examination and during the processing the result of the said examination, so 2011 examination result is being processed. It was detected that the OMR sheets of all the 3 sessions, that is session 1, 2, and 3, were evaluated with the answer key of session 2 only, and as a result whereof, it was revealed that OMR sheets of session 1 and session 3 of preliminary screening examination were not properly evaluated due to technical fault in evaluation of OMR sheets. Please see. First, there was a preliminary examination, preliminary screening examination. The previous paragraph, paragraph D. So and so candidates had participated in the
Held on 28/11/2010.
Yes. Then out of 26,445 candidates, 24,577 candidates had participated in the subsequent written examination in 2011. Now, Commission wants to believe this court that in 2024 or 2025, in compliance of the Honorable Division Bench order, they were scrutinizing the preliminary examination results, which was a stage ahead, a stage anterior to the written examination.
Mujumdar, my specific question, sorry for the repetition.
Please.
As I have seen, I have gone through the files. My specific question is that during the pendency of the appeal before the division bench and after disposal of the appeal and in course of filing successive 3 applications praying for extension of time, such alleged flaws have been brought to the notice of the division bench.
Never.
In this composite affidavit, has it been declared by the, has it been disclosed by the commission as to on which day or within which particular period such flaw was detected?
Nothing. But I have showed your lordship page 11. But that's The stand taken. আর আমার না কোর্টের রেকর্ড থেকে
Yes, Mr. Manjan. Next.
Now, then the commission comes with the explanation that the virus of certain provisions of the Madrasa Act were challenged before the Honorable Court, which ultimately had traversed up to the Honorable Supreme Court. Then please come to page 18.
Page number
18 of the affidavit. The paragraph L, the second paragraph on the first subparagraph on that page, that the commission could not continue with the said recruitment process due to prolonged lockdown of COVID-19. The commission filed further applications being Can 8 and Can 9 of 21, seeking another 6 months time to conclude such process. Now that's
before the Honorable Division.
So that's a final answer to your Lordship's query. The said applications were moved on 12th September 23 and the same were allowed by this Honorable Court by granting 6 months further time to complete the selection process for the post of Group D. On 12/9/23, the learned advocate for the commission submitted before the Honorable Division Bench that an affidavit disclosing the technical errors of the commission in evaluating the OMR sheets of Session 1 and Session 3 had been disclosed in paragraph I in the said affidavit in connection with WPA of so-and-so Osman Ali Shah in another case. Crave leave to produce the affidavit.
Just a minute. What does it mean? On 12/9/2000, an advocate for the respondent submitted before this Honorable Court that an affidavit disclosing the technical errors of the evaluating were in connection with which matter?
Osman Ali Shah versus State of West Bengal. That is another matter.
Another matter.
Another matter.
Before the division bench, it was not yet.
No, that's the what has been pleaded is the learned advocate had submitted this. But I don't find any such submission recorded though.
Has the copy of the affidavit has been annexed?
Not crave leave to produce the affidavit. Then please see paragraph M. That after 12th September 23, the commission again started the process of re-evaluation of the OMR sheets of all the sessions of the preliminary examination. But there were two examinations, one preliminary, one written. For the post of Group D held on 28/11/2010 with proper answer key of those respective sessions, and thereafter it was detected that 73,978 candidates who had appeared in the preliminary screening examination for the post of Group D on 28/11/2010 were eligible for written examination held on 29/5/2011, but had not been allowed to sit in the said written examination held on 29/5/2011 due to the technical error of the commission as stated herein above. The commission could not complete the whole process due to Lok Sabha election. Then the skipping over 1 or 2 lines.
Mr. Mujumdar, just a minute. Article 6. 13(6) से the last order was passed in MAT 907 of 2018 on 13/6/2024. Am I correct, Mr. Mujumdar? Whereby the division bench granted 3 months time to publish the result.
My lord.
as directed by the coordinate bench. Am I correct, Mr. Majumdar? So 13.6 means the commission ought to have disclosed, ought to have published the result by 12/9/2024. Has it been further extended? So by 12/9/2024, the commission published the result.
So not we approached this court praying for implementation of directions passed by the Honorable Court in earlier round.
Mr. Dhar, your client deposited the cost of rupees 2 lakh with the authority?
I'm told yes.
Yes, then. Sorry, Mr. Vindan. Place paragraph number M. What is your contention with regard to M?
Yes, not I was placing M, paragraph M.
Page number 19.
Again started the process of re-evaluation of the OMR sheets of all the sessions of the preliminary examination for the post of Group D held on 20th November 2010 with proper answer key of the respective sessions, and thereafter it was detected that 73,978 candidates who had appeared in the preliminary screening examination for the posts of Group D on 28/11/2010 were eligible for written examination held on 29/5/2011 but had not been allowed to sit in the said written examination held on 29/5/2011 due to the technical error of the commission as stated herein above. And your Lordship has perused that paragraph M. Now please keep this paragraph beside page 74 of my writ application, the division bench order. Has your Lordship got that?
Give me a second. Page number
74
of the writ petition.
Of the writ petition.
Yes.
Paragraph 12.
Yes.
The cascading effect of permitting the litigant to take a different stand at different stages is that the litigation would remain open and it would augment and encourage the litigations to travel in the docket of the court, and there will not be any certainty in the rights claimed by the parties. We are unable to accept the contention of the applicant that a plea was taken that there has been a large discrepancy in the scrutiny process, and therefore the authorities have decided to make a fresh scrutiny so as to invite several other eligible candidates to participate in the written examination. But although not specifically said, what was the session 1, session 2 or session 3, but paragraph 13 squarely turns down any such plea.
So according to you, the division bench, while passing this judgment or order, has practically sealed the hands of the commission to go to for effecting any further
scrutiny of any nature whatsoever. Now paragraph 14. Such plea having taken in the writ petition as well as in the instant appeal, but was not found favor, cannot be re-agitated in an application seeking extension of time to complete the process. There is a complete apathy on the part of the applicant in implementing the order in its true spirit, and there is a lackadaisical attitude perceived from the aforesaid conduct which needs reprimandation. Now, this scrutiny could also be not this session 1, session 2, session 3 game. Nobody knows. But whatsoever technical plea or scrutiny, defect in scrutiny, this was considered to be an apathy and effectively and emphatically turned down by the division bench of this honorable court.
Come to page number 17.
Yes.
I'm sorry, paragraph number 17.
My lord. That's the direction.
Page number 75 of your petition.
We would have proceeded to reject the said application, but considering the plight of the candidate.
Read from, we are unable to comprehend.
Yes, we are unable to comprehend the stand of the applicant that further written test is required to be conducted when the same was not accepted by the single bench as well as the division bench, and the direction was plain and simple that after conducting the written examination, the answer scripts are to be evaluated and the panel is required to be prepared indicating the successful candidates. Now, that's what the court wanted to be logically ended and not re-agitated.
So, Mr. Mujumdar, would it be correct to say that on conjoint perusal of paragraph 12, 13 and 17 of your writ petition at page number 75, 74 and 75, according to you, division bench practically turned down the plea of the commission for taking any further examination in respect of the same recruitment examination as has been held on 29/5/2011. That is your stand.
That's my stand.
I understand.
But please not permit me to read paragraph 18 at 75 as well. Page 75, paragraph 18. Taking a plea that centers for conducting the written examination was a step taken in due implementation of the order appears to be farcical approach and to some extent in defiance of an order passed by the single bench. However, taking a pragmatic view of the matter, we extend the time for a period of 3 months from date to complete the exercise strictly in terms with the order of the single bench as affirmed by the division bench. Now, after these caustic observation made by the honorable division bench in relation to the so-called exercise or of scrutiny sought to be undertaken, but I would go to the extent of submitting that this affidavit is an abuse of the process of court.
It's contrary to the direction passed by the division bench.
Not only direction, the division bench castigates the commission. Such scathing remarks is sought to be not obviated by you of this purported explanation.
Then, Mr. Mujumdar, according to you, how the commission justified their action in this comprehensive affidavit?
But that's the stand. Session 1 and 3 were.
No, that I have seen. How do they justify their action? I have understood that some persons have been left out. Scrutiny of it has been evaluated with the screening test of the answer key of the screening test of.
That's also untrue. That's also untrue.
How have they made any endeavor to justify their action in which according to you contrary to the view taken by the division bench as has been just placed before this court?
But the stand taken in this opposition squarely reflects not that stand of the commission. Now, that's not a clear abuse. After paragraphs 13, after those page 75 and 76, to come up with a stand and say that on further scrutiny we found this, it's really an abuse of the process of court. And if the commission in that particular page 18, page 13, if that affidavit is the sole defense or not, which was sought to be projected by the learned counsel appearing representing the commission at that stage, that has been taken care of then.
That order is passed on which day?
13. That was passed on
13
June 24.
13 June 2024.
Now, please come to note the bold stand taken at page 20.
13 June 24. Page number
20 now.
20
of the opposition, comprehensive opposition.
Page number 20. 20.
20.
Yes, sir.
Just after the quotation from the division bench order in the middle portion of the page, your lordship will be pleased to find a paragraph beginning with the words by such order. Now, he refers to the 13 June 2024 order of the division bench. Then, by such order, the Honorable High Court has not restrained the recruiting authority from holding the written examination of 73,978 candidates who were successful in the preliminary screening examination held on 28/11/2010, but could not be allowed to sit for the said written examination held on 29/5/2011 due to the technical error of the Commission in earlier evaluation of the OMR sheets. Subsequently, the recruiting authority published the notices one after another for holding written examination of the said left out successful candidates who were successful in the preliminary screening examination held on 28/11/2010. On 30th July 2024, that is after the division bench order, the recruiting authority published a notice to complete the first SLST within 10/9/24. Thereafter, by a notice dated 4/8/24, the Commission published a list of 24,577 candidates who appeared in the written test held on 29/5/2011 and on 5/8/2024, published a list of 73,978 candidates who were successful in the preliminary screening examination held on 28/11/2010, but could not get the opportunity to appear in the written examination due to technical fault and error in evaluating their OMR sheets of preliminary screening examination.
There is another challenge.
Not how audacious, what more could be a better example of an audacious conduct? Complete disregard to the observation made by the Honorable Division Bench. But each and every sentence or line your lordship goes through, but this will only exhibit not a complete abuse of the process of court.
Yes.
Admittedly, no fresh candidate has been called for or allowed to participate in the written examination except the applicants who appeared in the preliminary examination held on 28/11/2010.
Yes, sir.
But this is more or less the stand of the Commission, and the other stand is petitioners had already accepted the notices of the fresh examination. Therefore, they are stopped by conduct from challenging that has already been conclusively decided as so far as the right to challenge is concerned in the two orders passed on August 2024 and October 2024. Now, please come to if you didn't reply to the my lord. That Commission had filed an application for modification of the interim order. In WPA 21918 of 24. এটা হচ্ছে তোমার ওইটাতে হাফিজুল হক।
That is scan 4 of 2024.
Yes, scan 4. No, affidavit in reply, not affidavit in reply to our code. Affidavit in reply in connection with WPA 2191. Affidavit in reply. But please come to.
You are talking about?
But I am talking about an application being CAN 4 of 2024. Yes, I am grateful to your lordship.
In 2198. 2191 of 2024 আগে ওইটা পারবো। I don't know here.
This is that can is also available in the affidavit in reply in connection with the writ petition. Affidavit in reply will also do. Affidavit in reply take the
ওটা সিটগুলো আলাদা করো এখন না কিন্তু রিপ্লাই অ্যাপ্লিকেশনটা কোথায়?
And that application is enclosed to the affidavit in reply. And that's annexed to the affidavit in reply. And I'll just bring your lordship's kind notice to that. But the application begins at page 22.
ওইটা বার করুন না আমি দরকার ওটা ক্যান 4টা বার করুন।
Can 4 is annexed to the affidavit in reply. Your lordship may get it from.
I want to see original can 4 of 2024.
In the can, please come to page 29.
They want modification of Justice Sinha's order.
Yes, this was an yes.
Yes, sir.
Please come to page 29, paragraph 6 of that can.
Yes.
Paragraph 6.
So by filing this order, they want modification of the order date 25/11/2024.
Justice Sinha. There are several other candidates challenging the report of 3-member committee constituted by the order of the Supreme Court filed their respective writ petitions before the Honorable Supreme Court. So many candidates alleging that they are presently working in the respective Group D posts in the different aided madrasas also filed their respective writ petitions before the Honorable Supreme Court. And the Honorable Supreme Court in all pending writ petitions was pleased to observe that interim relief granted by the court in the writ petition being WP Civil number 566 of 2024 will operate even in these matters and thereafter. So many candidates and the writ petitioners before the Honorable Supreme Court who are allegedly working in the concerned madrasas in the Group D posts have been protected in terms of order of the Honorable Supreme Court dated 30th August 2024. Page 51.
Page?
The next page, I'm sorry, page 30. But the third line from the top, now please see the second line. The recruiting authority declared the final vacancy of 297 as on 1/1/2011.
Page number 30, which line, sir?
The second line from
Yes,
the
yes,
top.
recruiting authority. Yes, sir, I got it.
Declared the final vacancy of 297 as on 1/1/2011. The Honorable Justice Amrita Sinha, by interim order dated 25/11/24, was pleased to pass the following order. Not I placed that.
Yes, sir.
The West Bengal Madrasa Service Commission started the process to comply the solemn order dated 25/11/24, passed in connection with the instant writ petition, and intimated the respective madrasa authorities having the reported vacancy of Group D, whether there is any restraining order pending before any competent court of law. In terms of the notice of the recruiting authority, the concerned madrasa authorities intimated the recruiting authority that as many as 9 vacancies are subject matter of consideration before the Honorable Supreme Court in connection with the writ petition civil number 566 of 2024 and other connected identical writ petitions till order dated 6/12/2024. In terms of the order of the Honorable Supreme Court dated 30th August 2024 and subsequent orders passed in writ petition civil number 566 of 2024 and connected identical writ petitions, and all the petitioners therein are covered by the interim order passed in Najma Khatun in writ petition number so and so. The Commission is unable to fill up those posts and also unable to recommend any candidate to those vacancies which are the subject matter of pending writ petition before the Honorable Supreme Court. And until and unless the above mentioned pending writ petitions before the Honorable Supreme Court are disposed of, the present applicants are unable to give effect to the direction as contained in the order dated 25/11/2024. What does that order say? No further examination.
25/11/2024. I believe it is your contention is restricted to the result of the written test dated 29/5/2011.
Not your lordship's order was really taken note, was really fructified. Your lordship's order,
what they intend to say, I fail to understand.
They want to conclude the process in terms of the order of 25/11/24. Only keeping those 9 vacancies apart, or not persons who are already working apart.
Are those subject matter of the instant recruitment process?
So there was some writ petition in the Honorable Supreme Court pending. As the Commission says, there are 9 vacancies out of 297. So apart from those 9, they want to comply with the 25th November 2024 order. And the 25th November 2024 order, in line with the Honorable Division Bench, in line with your Lordship's interim order, expressly prohibits any conduct of a second examination. The Commission initially was, please come to paragraph 8. The Commission initially was not a party before the Honorable Supreme Court, and the present recruiting authority has been able to identify so far 9 vacancies out of 297 vacancies which are subject matter of consideration before the Honorable Supreme Court in the pending writ petitions filed under Article 32 of the Constitution of India.
No, Mr. Majumdar, please enlighten this court whether subject matter of the subject, whether the vacancy, which is the subject matter of the vacancy, which is subject matter of
2011 process.
Subject matter in the subject matter of consideration in the earlier round of litigation before the single bench and in the earlier round of litigation before the division bench is identical with the Supreme Court matter.
Yes, please come to that next paragraph 8 I was placing.
Fail to understand what is the stand.
The Commission initially was not a party before the Honorable Supreme Court, and the present recruiting authority has been able to identify so far 9 vacancies out of 297 vacancies which are subject matter of consideration before the Honorable Supreme Court in the pending writ petitions filed under Article 32. Then the next paragraph. The Commission is duty bound to comply the order dated 25th November 24 passed in the present writ petition, but due to the interim order dated 30th of August 24 by the Apex Court, the Commission is unable to comply the same unless the interim order dated 25 November 24 is clarified or modified, keeping in consideration of the order of the Honorable Supreme Court. The writ petitions pending before the Honorable Supreme Court was lastly moved on so and so. But Lordship may come to the middle portion of that page. There is a sentence beginning with the words, as on 6th December 2024.
Yes.
There were 32 petitions filed by several candidates, including the candidates allegedly working in the post of Group D. And the concerned Madrasa authorities, having 9 vacancies for the post of Group D, intimated the West Bengal Madrasa Commission that the reported vacancies uploaded on 5/10/24 are the subject matter of consideration before the Honorable Supreme Court. From time to time, several Madrasa authorities have been intimating the Commission regarding the status of the Group D vacancies, that their respective vacancies are under consideration before the Honorable Supreme Court, where the Madrasa Service Commission is now a party. paragraph 9 on the next page. On 27/9/24, the Honorable Supreme Court allowed the intervention application of the Commission in respect of the writ petition being civil number 566 of 2024, where there is no Group D candidate, but in connection with the identical writ petitions, there are so many Group D candidates who have challenged the order or report of the three-member committee constituted by the order of the Supreme Court. As the connected writ petitions have not been served upon the recruiting authority directly, so the Commission could not disclose the same fact of the interim order dated 30th August 24 passed by the Honorable Supreme Court at the time of hearing of the present writ petition on 25/11/24, and the Commission had no deliberate laches for not disclosing the fact of the interim order of the Honorable Supreme Court at the time of hearing of the present writ petition on 25/11/24. After the issuance of the notices dated 29/11/24, the concerned respective Madrasa authorities and the DIAC intimated the present applicants that their respective vacancies are subject matter of consideration before the Honorable Supreme Court in different writ petitions. The Commission is regularly getting letters from the respective madrasas that the respective vacancy are under consideration before the Honorable Supreme Court. As per the cause list of 6 December 24, 32 writ petitions have been filed before the Honorable Supreme Court, and there are huge number of Group D candidates who filed the writ petitions challenging the report of
all those are restricted to 9 vacancies.
9, and they say that other persons have joined in. Huge number of Supreme Court constituted a committee. Who are the persons working? So initially the committee said 9 persons. Then they said no, there are more. So more persons have joined. They said
No,
be that
more persons may join, or vacancy remains constant.
Vacancy is 297. But the question before the Supreme Court is whether persons already working should be absorbed in such posts or not. Then the number of
that is restricted to 9 vacancies, I believe.
9, and probably some more have joined. Yes. That's the Commission stand. Please come to page 34.
Candidates who filed the petition.
32 writ petitions have been filed.
Yes. So that will probably alter the number of vacancies in the long run.
Very good.
But then not the stand taken in the modification application by the Commission is we are trying to comply with the order of 25th November 2024, which is in line with your Lordship's first interim order.
So, Mr. Mujumdar, I believe, would it be your, it is your contention that while preferring an application being Can 4 of 2024, the Commission has taken, according to you, the shelter of pendency of litigation before the Honorable Supreme Court, and at that time also the Commission has not disclosed regarding the subsequent flaws regarding selection in the selection process, scrutiny in respect of examination on 29/5/2011. It is your contention.
And not one is filling up of vacancies through issuance of appointment letters. Not appointment follows a recruitment process. Recruitment process will end till the preparation of panel, or not say before issuance of the appointment letter. Not the court restricted this exercise of a stage up to the issuance of appointment letter to the 2011 examinees.
Will you kindly repeat your submission once?
What did the division bench order mean? The Commission should restrict its exercise apropos the or inter se the 2011 candidates. Don't take any further test.
Absolutely.
So you complete the exercise confining yourself to those persons only.
And publish the result.
Publish result.
You restrict yourself with the outcome of the result of the written test as taken on 29/5/2011 and no others.
And 24,557 candidates were found to be eligible. Don't rope in these 73,000 more candidates. You complete the process. As and when the Supreme Court will decide the fate of the other petitions, that will only determine the number of vacancies. This 297 could be say 230. That will come at the stage of issuing appointment letters. This will not impact the process. The recruitment process will not be impacted by that pending litigation in Supreme Court. এটা তো ভ্যাকেন্সি রিক্রুটমেন্ট প্রসেসটা তার আগেও Commission has declared 297 vacancies in 2010.
I understand your contention that for the sake of argument, even if it is accepted that the commission's plea as has been raised in Can 4 of 2010 is acceptable, it will alter the vacancy as per the order of the Honorable Supreme Court, but it does not touch the merit of the examination which has been completed on 29/5/2011 and which was directed to be completed by publishing the result by the Honorable DB Submission. That is your contention.
Scrutiny,
Very good.
scrutiny.
Come to the next point.
No, that's all.
That's all.
That's all.
Very nice.
And what only to show by way of an example that session 1, session 3 were intermingled with session 2, and session 1 answers key were not correctly evaluated, session 3 answers key were not correctly evaluated.
Mr. Mujumdar, I have some question of
my lord.
Admittedly, the first written test was conducted on 29/5/2011.
10. Written test, yes.
Written test,
Written test in 2011.
over which the direct you want the publication of the result.
Right.
Now, the subsequent written test was taken on 1/9/2024.
24.
Am I correct, sir? First was taken on 29/5/2011, and the last one was taken on 1/9/2024. Pursuant to the notices under challenge, definitely two sets of questions are different.
That's not point taken in the affidavit in reply. It's not a level playing field.
So my question is whether two separate written examinations for the same recruitment process is permissible or not.
That was a point taken in the affidavit in reply.
So why have not you have raised that point?
Yes, not in the affidavit in reply. I have taken the point of Article 14. In a same recruitment process, there cannot be two standards made applicable. One set of questions
for the Madhyamik examination or higher secondary examination or BA BSc BCom examination or of the year 2025. Can there be two separate sets of question papers? There may be same set of question papers having different combinations.
Level playing field is not there.
But can it be on different two question papers?
It can never be. No, just show the paragraph.
We have not raised the point that why the court will raise that point.
My petition,
it's also there. It's also there. Not only if that entire exercise is gone, not by reason of a division bench order being implemented, then not your lordships are not required to.
No, Mr. Mujumdar, you must not take any chance.
As very not I stand
simply because I am asking some favorable question.
No,
does not mean that I'm
I'm
leaning in favor of you.
But I no.
Mr. Dhar, please pardon me that your judge is a very talkative judge. I am telling.
No. That is the nicest part, because otherwise our profession is very dry. A little bit of the feeling of being wet is this.
I would put it in a different way. A lawyer's wisdom is always a borrowed wisdom.
That is
we borrow it from your lordships.
No. That borrowing is also reciprocal, Mr. Mujumdar, I can say.
The art of originality, there is a saying, the art of originality is basically an art of not telling the source. That is the borrowing. But that is applicable for everywhere and for every.
Any more point, Mr. Mujumdar?
The 2 points not basically
very
about supplement.
Now tell me who will argue? Any other?
Oh, not only to show not that the stand taken by commission is incorrect, that session 1, session 3 the answers keys of session 1 and session 3 were locked with session 2. That is incorrect because some of the petitioners had also appeared in session 3 examination. 1 and 3 examination, they have also been, their names have been published in the written examination. Very good. But this is an instance not of one or two employee persons.
What is that?
But this record, not when showing that not petitioner number 1 and 8 probably.
1, 12 and 53.
1, 12 and 53. Not they participated in
case of Abdul Latif.
Session 1 and 3.
1 and 3.
Mr. Majumdar, your clients, that is in WPA 24588, they are successful in that examination.
Not everybody who is approaching the court, co-petitioners are all successful.
They are found to be successful in the written test as held on 29/5/2011.
Subject to correction, they are not successful.
I will hear you, sir. Yes, who will argue? Who will adopt the argument of Mr. Majumdar?
I
To an extent. Let him know, I shall join.
item number
You are in.
item number 50, my lord.
Will you kindly
WPA number, my lord. 26.
Majumdar has not yet completed. Just to
Oh, sorry.
I had argued 44 and 46.
No, I have stated that 24588 of 2024 is the lead one.
44, item 44.
এই এটা কই আমি নোট করলাম বাসুদেব পেজের এটা কই
Mr. Majumdar, kindly place the number. Kindly tell me the number.
WPA 24588 of 24.
That I have noted.
Then
Next.
WPA 25438 of 24.
5438
of 24.
Next.
WPA 1436. No. Oh, sorry. WPA 21918 of 24.
21.
WPA 21918 of 24.
I will start. Item number 50 is mine.
Give me a second, sir.
Yes. Ashdev page. I mean, WPA number.
Yes. What is the case number?
My case number WPA number 26237 of 2024.
25.
26.
Oh, 26.
237 of 2024.
WPA 26237 of 2024.
Yes.
Mr. Samim.
Yes. Kindly take the writ petition first.
দাও ভাই দাও একটু দাও নেব সব নেব 26237
বসো দাদা এখানে বসো এই দাদাকে চেয়ার দাদা
শোনাও ভাই
Mr. Samim.
Yes.
You are SHAMIM.
SAMIM.
No, H is absent.
Absent.
Mr. Samim.
Yes.
So far your writ petition is concerned, the subject matter of challenge is the notice dated 9/8/2024.
Yes, yes.
And further is your prayer for cancellation of the written examination held on 1/9/2024.
Yes, yes, yes.
Am I correct, sir?
Exactly, madam. Now, madam, why I asked
এই ফাইলটা দাও গো
ফাইলটা
26237 এইগুলো নামো আস্তে আস্তে এইটা একটু কাছাকাছি রাখো অর্ডার শিটটা এখানে রয়েছে তো টু সিক্স টু থ্রি সেভেন ফাইলটা দিন Mr. Samim, you heard the argument of Mr. Majumdar?
Yes, I will repeat. We will not repeat any single sentence.
Please add if
Yes.
you have brought anything.
Yes, yes. And I will my lord, never cited the division bench because of that, my lord, already it is cited.
Yes, sir.
Kindly take, my lord, page number 14 of my writ petition. Para 14. Specific averment. What my lord says that it's specifically avoided in my writ petition, original writ petition. Your petitioner, what
Para
is
14 or page 14?
page 14, para 14. In page 14, para 14, bottom.
এটা কোনটা দিলে কোনটা 26237?
Yes, my lord.
Page 14, there is paragraph M and N.
No, my lord. I believe para 14. Page 14, para 14. I believe the other writ petition is given to my lords.
I'm sorry, it is, I'm seeing the AVAB now.
It's original writ petition, my lord.
I got it. Sorry.
It's okay. It's okay.
Yes, sir.
May I start, my lord?
Yes.
Your petitioner state that the action of the commission is also contrary to the recruitment rules. There is no provision to conduct a separate written examination. That's my point. There is no mechanism mentioned in the recruitment rules to meet up the problems of separate examination. The question paper were not same in case of separate examination. An easier question may given in new examination to make a pathway for their favorite examination. In other examination where two or more separate question paper were set, in many cases, normalization mechanism were followed. But in the instant case, there is no such mechanism to put all participants in same footing. In what happened, my lord, in central government, suppose 2 days or 3 days, the examination is conducted. In the case of railway, they adopt a mechanism that's called normalization mechanism. But here, my lord, I will place the recruitment rules later on. Because in that examination, if you want to put separate sets of question paper, then you ought to adopt a mechanism, that a modern mechanism that's called normalization. Normalization, scaling, all are the mechanism to meet up this type of problem. But here the case is that, my lord, they complete divorce the recruitment rules. I will place the rules later on. Before that, my lord, I place my case, my lord, in pleadings, my lord. No such mechanism to put all participants in same footing. Recruitment rules did not mention about any such mechanism, but the commission has taken a separate written test for the 73,978 candidates. The action of the respondent commission cannot sustain in the eye of law. Therefore, said notice dated such and such and the impugned action of the respondent need to be set aside as early as possible by the Honorable Court. Para 15. Your petitioner state that the notice by the commission is bad in law, bad in the eye of law. It is contradicting the order of the Honorable Division Bench. That means 13 June 2024 Division Bench order. The petitioner state that it has been decades since the examination was held. The writ petitions filed before the Honorable Single Bench was with the prayer for publication of result, which has not been complied with. The petitioners, along with several same footing candidates, are suffering due to the delay, and holding another written test would create further complication and delay, and the petitioner will be deprived of the opportunity. The commission cannot conduct a fresh examination of same candidate. The examination process need to be declared as bad in law. Now, my lord, what was the commission stand in earlier before the division bench, my lord, through CAN 20, which is annexed with the comprehensive affidavit. My lord, kindly take the comprehensive affidavit.
Comprehensive affidavit লাগবে কোথায় গেল comprehensive affidavit কোথায়
comprehensive affidavit
নামালে ওটার মধ্যে আছে
no
24588 এর মধ্যে আছে
একটাই স্যার পেজ নাম্বার 152
24588 এ পাঠাও কেন খুলতে বলেছি দেখেছো তো আজকেই খুলবে সব yes
my lord, kindly take page number 152 on 13 June 2024.
Give me a second. Yes.
On 13 June, my lord, this application was moved before the division bench. In connection with MAT 907, CAN 20 was moved before the division bench. What was the pleadings in this CAN? That is important. 152, page number 152. We start from page number 152. I just skip the para 1 and 2. Para 3 is very relevant.
Yes.
I read. The appellant, that means the appellant commission, state that on 19 September 2023, during the pendency of such application, the had already taken a policy decision to conduct a fresh written examination of total of 1,164 candidates. The commission take this policy decision. My first question is that from which provision of law they got this power, empowered? How the commission is empowered to take a policy decision after finishing everything, they will conduct a further written examination. Now, a very interesting fact came out thereafter. Of conduct a fresh written examination of a total of such and such candidate, that is 74,618 eligible candidates, which were left out along with 26,444 candidates who had already appeared in the written examination of Group D held on 29th May 2011. The appellant state, the very next paragraph, the appellant state that upon passing of the order dated such and such, the following step has been taken to comply with the order passed by the Honorable Court.
Mr. Samim.
Yes, my lord.
So far as paragraph number 3 is concerned,
yes.
What is the stand of the commission? The commission intends to take examination of all the candidates.
No. Kindly take this. May I read again?
Taken a
it will clear by the last two lines. Page 156. It is cleared by the last two lines. They want to conduct further examination, although this is not a very clear, but the intent is that the spirit of this paragraph is that they want to conduct fresh examination in respect of 74,000.
Just a minute, sir. Have taken a policy decision to conduct fresh of a total of no, Mr. Samim. Paragraph 3 says such and such had taken a policy decision to conduct fresh examination of a total of 1 lakh and what candidates.
Yes.
So their intention is to take fresh examination of the candidates of 1 lakh and what. That is 74,000 and odd eligible candidates which we have left out along with.
That
so
is,
they intend to take the fresh examination.
Thereafter, the sentence is not yet completed. That is, i.e., 74,618 eligible candidates which were left out, along with 26,445 candidates who had already appeared. That means who already appeared, which will be more clear because of they give a tabular chart.
Mr. Samim, paragraph 3 clearly indicates that the commission had taken a policy decision to conduct a fresh written examination of total 1 lakhs and odd candidates, which includes 74,618 were left and to plus 26,440
already appeared.
So total will come.
That is the number. Because of that, kindly take page number 4 of this comprehensive.
Just a minute.
Before that, kindly, if my lords wants a list of date, that will be give a clear picture to before this court, my lord. Page number 4 of this comprehensive affidavit.
Just a minute, sir. 74,618, 26,445. Sum total comes to 1,063, 64.
Kindly,
they intend to take a
kindly
fresh examination.
Yes, no. Kindly take, my lord, page number 4 of this comprehensive affidavit. Page number 4.
Just a minute.
It give a list of date that will give the clear picture of this about this matter. How this matter is cropped up. Para 5.
Page number
4 of this comprehensive. Because this is, it will help the court to ascertainment the fact. List of dates. The first entry, that is 27th March 2010, that is the publication of the advertisement date. Second entry, the commission conduct preliminary examination on 28th November 2010. The third entry, about 26,000, which my lord asked me about this 26,000. On 29th May 2011, already 26,445 candidates, they appeared in the written examination. There are second stage. So they appeared. What they did, they says, I will read the whole application. Because of that, what is the necessity of the reading, that will give the clear picture. I just put this list of date. Why? Because of that, it will give the clear picture. On 12 March 2014, the High Court order. Thereafter 9th December 2015. Thereafter 14/3. I just skip over. They even quoted in their tabular chart, and kindly take entry number 13. They even took cognizance of the division bench order. They already complied the division bench order by giving the cost portion. They can't take the contrary stand now. They already complied the order because they already gave the 2 lakhs cost. Now, after that, because this order came out after this application, moving this application, I will tally this application along with this comprehensive affidavit. Why? Because they took, which is already the decision is taken by the division bench. Now they want to re-agitate the same issue. Even the paragraph is totally the same. I will compare this to affidavit, this application along with this comprehensive affidavit. I will tally it. That's why I placed this application. Now, my lord, kindly take para 5.
Para 5 of what?
Of this scan application, page number 158. Page number 158. 8. They're comprehensive. The appellant further state that they have issued letter dated such and such to the district magistrate seeking for the availability of examination center to enable the appellant to conduct examination shortly. That means fresh examination of left out candidate. Such information regarding the availability of examination center is of vital importance for the issuance of admit card. Copy of the letter such and such. I just skip this portion, para 5, para 6. Now kindly take paragraph 8 and 9. 7, 8 and 9.
Page number
160. Got it, my lord?
Yes, sir.
Para 7. It is stated that as a result of aforementioned pre-scheduled business of appellant, that is conducting recruitment process of assistant teacher, the appellant have been under immense pressure and were unable to complete the entire recruitment process for the post of Group D in terms of order dated 12 September 2023. That paragraph 8, that the order dated 12 September 2023 is due expire on 11 March 2024. However, the appellant, despite the best effort, were unable to complete the entire process of recruitment of Group D candidate. Were unable to complete the entire process of recruitment of Group D candidate within such time frame as directed by this honorable court. Paragraph 9, very interesting. The appellant further state that they have received letter from the district election officer stroke district magistrate for the requisition of numerous staff of the West Bengal Madrasa Service Commission for the upcoming general election to the Lok Sabha 2024. Copy of the letter received from the district magistrate election officer stroke district magistrate is annexed here too and marked with letters such and such. Now, my lord, kindly turn page number 19. Now their stand. What is their stand? Same stand. Para 19. M. Paragraph M. paragraph 19. That after 12 September 2023, the commission again started process of re-evaluation of the OMR sheet. My second question, my first question was that from where they got this power to conduct a further written examination, because there is no such normalization procedure, because separate set of question paper. That is my first points of agitation. Second point of agitation, this re-evaluation. From where they got this power of re-evaluation of OMR sheet? Because if they want to re-evaluate the OMR sheet, there must be some statutory backup, because division bench is very clear. And
give me a second. Yes, Mr. Sain.
Yes, Margaret. So there is no such provision of re-evaluation of OMR sheet. My second point. Re-evaluation of OMR sheet of all the session and preliminary examination for the
second or third point. Your
the
first
third
point
yes.
was violation of recruitment rules.
Yes.
Your second point was no mechanism has been followed for normalization of the recruitment process.
There is no rule regarding second time holding of the written examination. So
And
there
third is no power to re-evaluate the
OMR. Yes,
as
I'm
per
great.
the recruitment rules.
Yes, I'm
Those
great.
those are the basically 3 points.
3 points. I will come up another points also.
Very good.
Normal re-evaluation of OMR sheet of all the sessions of the preliminary examination for the post of Group D held on such and such date with proper answer key of those respective sessions. And thereafter, it was detected that 73,978 candidates who had appeared in the preliminary screening examination for the post of Group D on such and such date were eligible for written examination held on such 29th May 2011, but had not allowed to sit in the said examination held on 29th May 2011 due to the technical error of the commission as stated herein above. The commission could not complete the whole process due to Lok Sabha election 2024 after completion of the Lok Sabha election 2020. The same point, because of the earlier occasion in Can 20, they took the same point. Here also, they took the same point. And the fate of the Can 20 is already decided by the division bench. How can they re-agitate the same point which is already decided? That's why I compare this paragraph with the earlier application. May I place the division? Sorry.
Are you in a hurry, Mr. Samim?
No,
let your judge note.
Because I am. কিরকম বদমাশ না
So, Mr. Samim, would it be your contention that the point or the defense has taken in this comprehensive affidavit is, since it is identical with Can 20 of 2024, in connection with MAT 907 of 2018.
Yes.
And since it has been, those issues have been decided by the division bench,
It is.
though the defense taken by the commission operates as a res judicata.
Yes.
That is your content.
Yes, my lord. That's my point.
Let me note, sir.
Yes, my lord. And now, my lord, the third point is, fourth point is that, my lord, how the
Yes, sir. Next.
my lord, now, my lord, I wants to refer the rule position. What is the rule position? This is the 2010 rule, my lord. 2010 rule. This rule called, because this selection process first SLST 2010 non-teaching staff is the rule regarding this matter.
মার্ক করো, ওই মার্ক করে রাখো WPA 26237 বলে, ওই যেটা দিচ্ছেন উকিল, নাহলে খেয়াল মনে রাখতে পারবো না, ওটা নোট করা রাখো। ইন WPA 26237 of 2024.
Yes, ma'am. Reported হয়ে গেছে রে, রিপোর্টেড পোরশনটা নিয়ে নেন, আনরিপোর্টেড অনলি। রিএভ্যালুয়েট করা যায় না। লিখেছে চুপ করো।
West Bengal Madrasa Service Commission recruitment, selection and recommendation of persons for appointment and transfer to the post of teacher and non-teaching staff.
Rules
2010.
Yes.
Very good.
Kindly take note of the rule, that is rule 12 onwards, my lord. Specifically, I want to canvas rule 14, 15, 16, 17, specifically rule 17.
Chapter 5.
Yes, my lord. Chapter 5 onwards, my lord.
Which rule you want to refer, sir?
Rule 11 onwards, my lord, because that is rule applicable to this.
That is
process.
chapter 5.
Yes, my lord.
Chapter 5 and chapter 6.
Yes, my lord. Chapter 5, chapter 6, and chapter 7. Specifically, chapter 7 is very important because there is about evolution. There is no such provision of re-evolution.
Chapter 6 and chapter 7. Yes.
My lord, rule 11 says about the form of application and fees thereof. I just skip it for the time being. Rule 12 is about submission of application. Rule 13 is processing, screening of application. For the time being, I just skip it. Now, my lord, rule 14, issuance of admit card. For the time being, I skip it. Rule 15 is very important.
Yes.
Rule 15 says about arrangement of written test, not tests. In singular form. The commission shall arrange for written test, not tests, under its direct supervision and control. The commission shall determine the scheme and syllabus of the written test, not tests. Prepare question paper and distribute the same to the examination venue through the custodian appointed by the commission. The commission shall appoint paper setter, moderator, observer, approve the list of examiners and experts, fix the rates of remuneration for paper setters such and such. The commission shall determine the number of papers for the written test, content each paper, duration of examination, and other matter relating to the state, region, such and such. Rule 16. Holding and conduct of written test. Again, written test. The commission shall hold written test of all the eligible candidates. They are also the written test, not tests. The commission shall decide the procedure and the manner of conducting the state, region, area of level selection test, and the prepare details instruction in this regard in accordance with the provision of the act and the rules made thereunder. The commission shall select examination. For the time being, I'll just skip it over. Rule 17. That is evolution. Very interesting. Evolution of answer scripts sheets. The commission shall get the answer scripts stroke seats of the written examination evaluated by the examiners, computer-based technique, and prepare a evaluation sheet, medium, post, subject category, and gender-wise on the basis of such evaluation. Now, preparation of list of candidates for persuasives. After the evaluation of answer sheet of the written examination, the commission shall prepare medium, post, subject-wise categories. There is the provision. So there is no such provision about second time written examination. That's my point.
That is called multiple test.
Yes, it never be a multiple test. If you want to adopt the multiple test, then there must be some provision in the rule itself. It is happened in the case of railway examination. It's happened in the case of staff selection examination. Because in that type of examination, there is in the advertisement as well as the rule, there is must be the specific provision. In that provision also they says we adopt the process of normalization or scaling. So there is no such mechanism of second time test. And one go, you ought to take the written examination. It might be the multiple center. There is another point is that there is no such provision of re-evaluation. Because
give me a second.
বলছি পরে শুনে নেবে পরে শুনে নেবে পরে শুনে নেবে নাহলে পয়সা লাগবে
The recruitment rules does not
confer
prescribe any re-evaluation.
My 2 point is there. In recruitment rules, there is no such provision of second time written examination. There is no such provision of re-evaluation of OMRC. Because re-evaluation, there is a hell and heaven difference between evaluation and re-evaluation. Because this is a statutory body. And statutory body, this statutory body, West Bengal Madrasa Service Commission, is empowered by the statute.
The rules have to be finalized before holding examination.
Yes, this rule framed by the state authority, and they, by adopting this rule, they process this selection process. So, being a statutory authority, they can divorce the rules. Divorce the rules amounts to the.
Understand. What is your next contention, Mr. Samin?
My next contention is that, my lord, I just summing up, my lord, that is all, my lord. I just summing up this, if my lord want, because of this is a settled proposition of law that re-evaluation is not permissible, because in our division bench hold it very recently in upper primary examination, the re-evaluation is not permissible if that is not backed by the statute. That is, I want to refer it. I will refer it later on if they wants to contradict it. Say, I did it, judgment. I just summing up for the okay. Okay.
Clear that by the using the word evaluation, my learned friend should indicate that.
If it is not clear, it will go in your.
Yes, your term.
Maybe. If the argument of Mr. Samimi is not convincing,
yes, you will agitate it. You will agitate it. You will agitate it.
So, Mr. Samim, please sum up.
Yes, my summing up this, my contention is that in 3 proposition of law. First is that, my lord, there must be a level playing field. Because in our country, there is no such right of employment. Equal opportunity in public employment, that's the fundamental right. If suppose 2 examination was conducted, in one sets of examination, easier test might be happen, and suppose the Article 12 authority might choose their favorite candidate in that sets of examination. So that's why the modern technology adopt, that is normalization. So it is because a huge number of participating candidates in that selection process might be happen. So that's why normalization process was adopted in that type of examination. But here there is no such provision. So that is not permissible. Second thing is that they did it. That means they divorced the rules. If they did it by divorcing the rules, it amounts to not giving the equal opportunity to all the candidates, it is liable to be set aside their action. Third point is that, my lord, that is, if they want to re-evaluate the OMR sheet, that must be backed by the statute. There is no such express provision of law to re-evaluate the OMR sheet. And my fourth point is that regarding the second time written examination, already division bench hold it, that is not permissible. So that is res judicata. That's 4 points. That's fine. That's extremely grateful.
Any other want to join in favor of the writ petitioners?
Date. Serial number 54.
Kindly place the case number. WPA
9578.
9578.
We have assailed the notice.
9578 কি ট্যাগড হয়েছে?
না, is yet to be tagged.
দেখি এটা আমার দিন একবার কি আছে দেখি।
I don't have the copy of the affidavits that they have used since it has come for the first time.
Subject matter is same.
Same subject matter. Only thing is, if I get a copy of the affidavit, then I can address the court whatever points they have taken on that. The affidavit that are used by the commission and other respondents in other matter must be the same stand in my matter also.
Mr. Dhara, please.
As far as if he wants the
9578. 9578.
Item number 49.
I have absolutely no difficulty. I can give a soft copy because I use the soft. Soft copy.
Comprehensive.
No,
9578.
because fundamental.
You'll get your chance to make your submission.
Has to be tagged and I'll get a copy of
I'll tag it today. Please remain, either you or your junior remain in court. Mr. Bhattacharya, you are appearing in?
Item number 49.
Kindly tell the WPA number, sir.
The copy is ready. That's good.
2609.
Yes, sir. নামটা কি?
Firdaus Shamim, this is Shamim Ahmed.
But you are minus H.
Minus H.
Mr. Bhattacharya is appearing in?
For the petitioner in item number 49.
What is the WPA number, sir?
26090 of 2024.
নামটা বলো তো।
চলো ওটা জয়ন্ত সর্দার।
Zero 90 2020 একটা নিয়ে নি no we are still 22 minutes are there একটা লাইন লিখে নাও তো উনি হচ্ছেন মিস্টার শামীম আহমেদ না এটাতে একবার লিখে রাখো এই WPA Mr. Bhattacharya is in.
No, for the petitioners be not in WPA 26090.
Yes, sir.
Please come to my writ petition. I
You
am
have heard, you have heard the argument of Mr. Mojumdar and Mr. Saki.
I know, my lord, what they have said. But I think, the other matter, my lord, the GTA matter was going on in the other court.
So please don't repeat. If you want to
comes
add
page-
something,
kindly comes to page 55 of my writ petition. But first, I invite your lordship to page 53.
what is your flag left?
Page 53.
Yes.
By this time, your lordship is aware that there was a written test, first SLST non-teaching, held on 29th May 2011. That your lordship has been aware by the submissions made by my predecessors, who were making submission, my learned senior friends. This document says that the list of such and such number of candidates kindly marks the number 24,577 who appeared at the written test of first SLST non-teaching 2010 held on 29/5/2011 is uploaded on the website of the commission. These 24,577 candidates who appeared in the written test Group D held on this will not have to appear in written test again. Has my lord got it? So this is 4th August 2024. A Bengali document also was published on 4th August, page 54.
Saying that appear korte hobe na.
We are those candidates. Our names figured in this 24,577.
Of course.
14%. Now, my lord, page 55 kindly comes now. That is the subject matter of challenge in the writ petition. পশ্চিমবঙ্গ মাদ্রাসা সার্ভিস কমিশন দ্বারা আয়োজিত such and such 28/11/2010 তারিখে অনুষ্ঠিত প্রিলিমিনারি স্ক্রিনিং টেস্টে যে 73,978 জন প্রার্থী যোগ্যতা অর্জন করা সত্ত্বেও 29/5/11 তারিখে লিখিত পরীক্ষা দিতে পারেননি তাদের নাম ও রেজিস্ট্রেশন নাম্বার পশ্চিমবঙ্গ সার্ভিস কমিশনের ওয়েবসাইটে who were eligible but could not appear লিস্টে দেওয়া হলো। এই 73,978 জন প্রার্থীকে আগামী এত তারিখে পশ্চিমবঙ্গ মাদ্রাসা সার্ভিস কমিশন দ্বারা পরিচালিত লিখিত পরীক্ষায় দিতে হবে। So this is 24,000 will not have to sit. 73,000 will have to sit. Now, this stand is in pursuance of decisions which your lordship will be finding starting from page 49 of my writ petition. Please see 30th July 24.
The instant writ petitioners are
the candidates.
Are amongst the 73,000 and
no, are amongst the 24,000.
24,000 and all.
We are covered by 4th August. We are not covered by 5th August. We are not.
You are the successful candidates on the of the examination held on 29/5/2011.
Mind. Successful, my lord, we were not called upon to sit for any examination. We are covered by that decision communicated on 4th of August 2024.
No.
Yes, we are successful.
That's called.
Now, my lord, please pardon me.
Page number?
My lord, first is page 49. This is for general information that in terms of order dated 23rd July 2018, in WP number 1722 of 2018, my lord, that 1722 order, my lord will be pleased to find at page 36 of the writ petition.
I've gone through.
Which was affirmed by order dated 13th June 2024. Now, my lord, pausing here for a moment. 13th June 2024 is an order passed in a disposed of appeal in connection with a can taken out by the commission. In connection with a can taken out by the commission.
36/2024 order.
Yes.
Can is for extension of time.
Yes. Now, my lord, pardon me for saying this. The original order of the appellate court is at page 67 of is at page 39 of my writ petition. The original order made by the Honorable Division Bench in the appeal carried by the Commission from the order of page 36.
24588 writ petition টা 10 জায়গায় দেখে লাভ নেই। original writ petition টা খালি আমার দিকে। Single bench passed the order on 23/7/2018.
My lord, 23rd July 2018.
The coordinate bench order.
Yes.
Coordinate bench order.
Yes.
And the judgment or the order dated 13/6/2024 is the first order passed by the division bench.
No.
No.
That was the last order.
I'm sorry.
Page
Then
30, page 39.
It is on 4th February 2020.
24th February 2020 is the initial order.
4th February.
So, what, Milord, I need not, Milord, trouble your lordship, apart from saying that the direction made by the coordinate bench in the writ petition carried by Showman Malakar is appearing at the internal page 2 of the order. And the direction was to forthwith intimate to the writ petitioner the result of evaluation of these answer sheets, and if he is qualified, then to prepare the panel in terms of Rule 18. If he is eligible as qualified candidate in terms of the.
You are reading the order date 4/2/2020.
Well, I am reading the order dated 23rd July 2018.
Single bench order?
Yes.
Oh, I see. Why are you referring?
Why? Because, Milord, the direction of the court. What was the direction? The direction of the court was, Milord, I am reading from internal page 2. Accordingly, the present writ petition is disposed of after recording that the writ petition
has been placed by Mr. Mojumdar.
Yes. Now, this was the direction. This direction was
been affirmed by the division bench
at page 39.
That is in on 4/2/2020.
Yes.
Only modification is extension of time.
Then the question of any examination, re-examination, subsequent examination, nothing. Please come to page 42. It has been argued, Milord. I am trying to just show your lordship, my lord, that the endeavor by the commission endeavor of the commission as would appear from paragraph 9 of the order dated 13 June 2024.
Mr. Bhattacharya, please listen me. Thereafter, please answer. The coordinate bench directed the commission to evaluate the answer sheets and publish the result.
And in the event of thing, my lord, in terms of the rule to proceed.
Absolutely. Such order has been affirmed by the division bench.
My lord.
Only modification is extension of time by 6 months. By subsequent orders on the basis of several CAN applications, interlocutory applications, the division bench time to time extended the order time.
Yes.
This much.
Last extension was 12 September 23, as would appear from paragraph 7 of the last order, my lord. 13 June 2024 order, if my lord kindly sees, my lord.
Yes.
Page internal paragraph 7 and 8. Then, my lord, this specious plea regarding a fresh examination and conduct of examination was taken before the Honorable Division Bench. Paragraph 9. Now, please see internal page 4, third line from the top. A litigant is not permitted to prevaricate its stand at different stages of the proceedings.
Which portion, sir?
You know, third line from the top at internal page 4.
Internal page 4, yes.
As my lord very kindly got it, my lord, a litigant is not permitted to prevaricate its stand at the different stages of the proceedings. If the plea was taken in the writ petition and the court ultimately disposed of the proceeding, even without recording any finding thereupon, it is deemed the said plea has not been accepted by the court and deemed to have been rejected. Even before the appellate court, it does not appear that any such plea was taken or argued at the time of hearing, and the order of the single bench was affirmed with modification to the effect that the time limit for completion of the entire exercise is extended for a period of 6 months. Interestingly, the first application for extension was disposed of, extending the time for a further period of 6 months, which necessarily implies that such plea which is sought to be projected for the first time in the instant application was not pressed and or pursued, as the authority decided to complete the exercise in due implementation of the directions passed by the court. A plea of res judicata also appears in the instant case. The plea which ought to have been taken or was taken and the decision have been taken finally, it would be deemed that the said issue has been decided finally and cannot be reopened at the subsequent stage of the proceeding. We are conscious that the plea of res judicata not only applies between two proceedings but has equal applicability at the different stages of the same proceeding. The principle of res judicata is based on public policy. The fundamental policy of the country is to bring every litigation to its logical end and shall not allow the litigation to continue eternally. The plea which has already been decided or comes within the purview of explanation appended to section 11 of the Code of Civil Procedure cannot be allowed to be re-agitated at the different stages of the proceeding as it is set at the rest at one point of time. The cascading effect of permitting, etc. Now, we are unable to accept the contention that a plea was taken. There has been a large disturbance in the scrutiny process, and therefore the authorities have decided to make a fresh scrutiny so as to invite. We are unable to accept. Not the Honorable Division Bench, its order cannot be referred to as a ruse as if the Honorable Division Bench permitted conclusion of the process in the manner ordained according to the Commission, which is apparently not appearing from the order. My Lord, please see such plea having taken in the writ petition. My Lord, I am reading paragraph 13. Discrepancy in the scrutiny process, and therefore the authorities have decided to make a fresh scrutiny so as to invite several other eligible candidates to participate in
So,
the
Mr. Bhattacharya, I believe it is your contention. The defense which has been taken in the comprehensive affidavit,
yes,
in connection with the instant writ petitions, have already been considered by the division bench while passing this.
Lord, with greatest of respect to my lord, with greatest of respect to my lord, please see just for a moment paragraph page 49. Before since your lordship is looking into page 46, please see page 49.
Yes, sir.
This is for general information that in terms of the order dated 23rd July 18 in WP number such and such, which was affirmed by order dated 13 June in MAT of the Honorable Division Bench. 13 June is the order that your lordship is looking at.
So practically, according to you, Mr. Bhattacharya, the finding of the Honorable Division Bench operates as a res judicata.
Yes.
In connection with their defense.
It does. Finding of the Honorable Division Bench is that this stand they cannot take first, and therefore any endeavor by them to conduct a fresh selection by way of 5th August 2024 cannot be countenanced because the division bench itself did not permit that and settled them with costs of 2 lakhs. Please see. I respectfully, Milord.
Give me a second.
I'm sorry, sir.
Yes.
Now, please see categorically paragraph 17. What is the division bench's verdict? That's the order of the Honorable Division Bench, and they cannot interpret it to suit their own convenience. We would have proceeded to reject the said application, but considering the plight of the candidates who have participated in the written examination and because of the careless conduct of the authorities, their fate is still in the lurch, or in other words, uncertain. We feel that the authorities must act strictly in terms of the order passed by the single bench as affirmed by the division bench. We are unable to comprehend the stand of the applicant that further written test is required to be conducted when the same was not accepted by the single bench as well as the division bench, and the direction was plain and simple that after conducting the written examination, the answer scripts are to be evaluated and the panel is required to be prepared indicating the successful candidate. So the fresh written examination was rejected.
So, Mr. Bhattacharya, I believe it would be your contention, kindly listen me, that in view of the decision of the Honorable Division Bench, the Division Bench did not permit the Commission to raise the plea that a large discrepancy took place in the scrutiny process, and therefore the decision of the authority to make a fresh scrutiny is no way permissible. I believe it is your contention.
And was rejected.
So, I believe it is your contention that when such plea was not considered favorably by the division bench as submitted on behalf of the commission, that plea cannot be taken, or that plea cannot be re-agitated in course of the instant writ petitions.
plea cannot be re-agitated by taking the shelter of the Honorable Division Bench's order. Please see page 49.
That I'm saying.
They have said that in accordance with the Honorable
Practically, according to you, by this order, while disposing the can, Honorable Division Bench has barred the commission
from
to
holding a
take
fresh
holding
test.
cross-examination.
Yes.
That's all. I understand.
But on the face of it, paragraph 17.
Anything you like to add?
Yes. Two more.
Very good. Asu, check them.
Wait.
Wait. Why supplementary debit? Why am I making unnecessary
No,
complication? This court has